was in the middle of your questioning. I was trying so hard not to laugh.
Well, that is yeah, that's one of the joys and pitfalls, I guess, of uh, telework or work, having your business at home.
Right.
Is you have those and no matter how much you plan for those things.
Nothing. You're right. Yeah.
Exactly.
We have a new puppy, so uh,
Oh, excellent.
we're not getting a lot of sleep at our house.
Yeah. What kind?
Well, we got her from the shelter, so she's uh, a mixed breed, but she's mostly border collie.
Oh, excellent.
Yeah, she's darling, but oh,
I have uh rescues also, and they both come from the All Ears Basset Rescue.
oh,
So they are both part Basset, but don't necessarily look, they're long and low, but don't necessarily look like hound. They're black and white, and they don't have really long ears.
oh,
So Jake, we think, is a Basset Springer, and we think Lila, who's also black and white, is part Beagle.
aw.
And they refer to that Basset Beagle as a bagel.
You better be careful, Madam Hearing Examiner. I might call your two beagles to the stand as witnesses.
Well, our Allison, our court reporter, was letting me know that she saw a door opening and saw one of the pups coming into the room where I am, and so was commenting, and she's saying she has a brand new rescue puppy.
Congratulations.
So,
Thank you.
yeah, those
Keeping us
are
up at all
exciting.
hours. Yeah, she's darling, but oh, handful.
Don't tell my 4-year-old almost to be 5-year-old, because you know what he's asking for his birthday, and it's a dog.
Aha. Well, I'm sure there are plenty of these, whether they're specialty organizations or going to. I've been familiar with Espanola for a number of years, and I'm sure they have lots of pups and kittens and bunnies. Who knows what they might have. So always very rewarding.
And with oh, go ahead. I'm sorry.
Oh, go ahead.
No, it's all right. This is personal
No,
stuff.
please.
Oh, I was just going to say, and with a law practice and a 4-year-old, what's a puppy? That's just one word.
Yeah, exactly, Miss Lees.
Nothing
He
else.
got a little brother this year. He's not getting a puppy too.
Congratulations.
Well, that's true. That's true. Puppy 4-year-old. At this point, probably cost about the same. Perhaps later on, but I don't know. Well, I think we're waiting. And anything procedural that we need to address, we are live streaming already on YouTube in preparation for resuming our hearing. I did admit Mr. Rawing, but you can tell me, Miss Lees, is your preference that we go to Ms. Trammell, or that we just, since we have Mr. Rawing on here, that we just go ahead with him?
Yeah, SPS is prepared to call Ms. Trammell after Mr. Rowling's testimony has concluded.
Okay. Okay. I think the only person I do not see yet is Ms. Beatles, and we're about 1 minute from 9. Let me just say, I checked Dropbox this morning. There she is. I don't see your new testimony.
I
In
checked
there.
on that this morning too, and it should be uploaded this morning. And I'm
Okay.
going to be told when it is, so I'll let you know. And I apologize for it not being uploaded yesterday.
Okay. I just want to make sure that I checked a bunch of different folders looking for it, and it's like, well, just ask about that. Okay, so no one has anything procedural then that that we need to deal with at this particular point. And my state issued phone says 9 o'clock. So Allison, if we could go ahead and come back on the record. Good morning. We are beginning day 3 of our hearing in case number 22-00178. This is in the matter of SPS's grid modernization application. We are going to continue with examination of SPS witnesses. And Allison, if you would please swear the witness.
Mr. Rollring, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you. Good morning, sir.
Good morning.
Miss Lees, go ahead.
Thank you. Good morning, Mr. Rowling. Can you please state your name for the record?
Stephen Daniel Rollwing, Rohlwing.
And do you have in front of you what has been marked as SPS Exhibit 15 and 16?
Yes, I do.
Can you please identify SPS Exhibit 15 for the record?
SPS Exhibit 15 is my direct testimony in this case.
And was that testimony prepared by you or under your control?
Yes, it was.
And if I were to ask you the same questions today, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
And do you, are there exhibits attached to your direct testimony?
Yes, I have 6 exhibits attached.
And were those attachments to your, excuse me, I called them exhibits. They are attachments to your direct testimony, correct?
Correct, attachments.
And were those attachments prepared by you or under your control?
Attachments 1, 2, 3, and 6 were. Attachments 4 and 5 are Brattle studies that I did not prepare, but are used in my testimony, so I included them as well.
Okay. Can you please turn to what has been marked as Exhibit 16?
Okay. Yes.
Can you please identify that exhibit for the record?
This is my rebuttal testimony in this case.
And was that rebuttal testimony prepared by you or under your control?
Yes.
And if I were to ask you the same questions today, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes.
Do you have any attachments to your rebuttal testimony?
I do not.
And Mr. Rowling, I forgot to ask you, by whom are you employed and in what capacity?
I'm employed by Excel Energy Services, and my role is the Director of Risk Analytics.
Thank you. Madam Hearing Examiner, SPS moves the admission for SPS Exhibits 15 and 16 into the record.
Mr. Rowling, any additions, corrections, or deletions to either of your testimonies?
No.
All right. Is there any objection to what's been identified as SPS Exhibit 15, Mr. Rowling's direct testimony? Hearing no objection, SPS Exhibit 15 is admitted. Is there any objection to what's been identified as SPS Exhibit 16, Mr. Rowling's rebuttal testimony as affirmed by him here today? Hearing and no objection, SPS 16 is admitted. Ms. Lees.
Thank you, Madam Hearing Examiner. SPS passes Mr. Rowling on for cross-examination.
Very well. I believe that the first party that reserved time for questions was the Attorney General's office. Mr. Getko, you have questions for Mr. Rowling.
I do have a few questions. Good morning.
Go ahead, sir.
I'm sorry, I didn't hear it well just now. What is your position with Xcel Energy? I'm sorry. Sir?
The director of risk analytics.
Got it. Thank you.
Sure.
I'd like to start by just going to your direct testimony and referring to pages 30 to 32.
Okay.
And what we see there is that you discuss how SPS calculated AMI benefits associated with time of use customer price signals for the purposes of SPS's cost benefit analysis. I think this was covered in the hearing yesterday or the day before. Well, actually, no, this wasn't. Do you know what % of residential customers would need to enroll in a time of use rate to create the benefits that are identified?
I don't specifically know the number of residential customers that would enroll. In my analysis to capture this benefit, we relied on the Brattle study that's included as attachment 5. There are 2 streams of potential megawatt hours saved by residential customers within that study that we relied on. One is a stream where it's assumed an opt-in type of TOU program, and one considered an opt-out stream of saved, or basically dollars saved by customers because of a shift in use, and it's at the system level, so basically in megawatt hours. So I don't know the specific number of customers, but we did use estimates for megawatt hours saved by residential customers.
And it's probably not easy to do to understand right now what those megawatt hours would translate into for what we kind of term our average residential customer. Is that fair?
That's fair. We could do some, this hearing has had some, arithmetic online, as we go. We could do a little bit of that if you want to give it a shot. It's about 25,000 megawatt hours a year expected savings. So you could divide that by, approximately 100,000 residential customers. You could divide that by approximately 1,000 kilowatt hours, or you could kind of back into that perhaps. I am not going to do that in person, but I think you could back into it. But just that estimate, it's about 25,000 megawatt hours saved or transferred.
Okay. And my next question is maybe doesn't quite work. I was going to ask, because we had seen earlier in the hearing that we have about 0.011% of residential customer bills are encompassed by current time of use rate use. I was going to see kind of how much of an increase that would be in percentage terms, but do you know the current megawatt hours per year that are encompassed through time of use rates?
I do not.
Okay, I'm going to move along because I don't think it's valuable for us. We can figure that out later. With the estimate there of the 25,000 megawatt hours per year expected savings, if I understood you correctly.
Well, let me clarify that. 25,000 megawatt hours where there would be that would be a shift from on peak to off peak. So the customers would shift that much usage to off peak hours.
Okay.
And maybe I wasn't clear there, but.
And is that shift what we understand as the calculated benefit?
Correct.
Okay.
That's that shift because they would have lower prices for off peak.
Okay. Do you know if SPS could realize this amount of benefits from increasing enrollment in its existing residential time of use rate?
My assumptions in the model that the time of use rate participation would definitely have to increase over current levels for that to be realized.
And do you think you could do it through the existing? Do you think you could achieve that? Could SPS achieve that through the existing time of use, residential time of use rate?
Could I clarify that? Are you saying could we achieve that without AMI meters?
No, I think we should assume that the AMI meter. What could we do? Well, can you explain to me how it would make a difference with the existing residential time of use rate? I guess I was thinking without to begin with. So if you were just to use the existing residential time of use rate and increase without new meters, do you think you could achieve those benefits?
My model does not show that we would be able to do that without AMI meters.
Okay, and so with AMI meters and just the existing residential time of use rate, would SPS be able to achieve the benefits that were identified?
Tough question, because I'm making some broad assumptions within that Brattle study of a 5-hour window of a certain, savings for those megawatt hours. I believe, as Ms. Trammell already testified to, that we would want to really dig in and understand the usage of our customers to be able to really fit a time of use program to that customer base that is appropriate. So I don't think I can answer that until, given that we would need to be much more specific with our time of use program once we have that data through AMI and the usage information from customers.
So what I just understood is that you would need the data from the interval data in order to construct a time of use rate that would allow you to calculate whether you could achieve those benefits. And if I understood that correctly, then
yes. Yes, and in the model, I do show that those benefits come after some time of implementation. So we're not realizing those immediately. I'm using that assumption that we would develop that and then the benefits could be realized a little bit down the road.
So maybe to make the original question, just a little simpler, would it be fair to say that that you haven't been able to calculate whether you could achieve those benefits with the existing residential time of use rate?
Yes, that's fair.
Okay.
Mr. Rolling, I'd like to know, I seem to recall in the testimony that, I mean, that there are very few SPS TOU customers. Isn't that correct?
Currently, that is correct.
So, I mean, in performing this risk assessment on this benefit, I mean, actually coming to fruition of saving these 25,000 megawatt hours, isn't that kind of like winning the lottery?
It's actually a very conservative view. So of our total benefits that we are calculating for AMI, the TOU benefit, while 25,000 megawatt hours seems like a lot, it ends up being about 2% of the total benefit that we are saying that we are getting from the AMI program. So it's not, I would not classify that as winning the lottery. I would classify that as a conservative view of once we have that technology and those meters in place, of the benefit that we would get from customers.
So you think then that once the AMI goes into effect, that's going to spur SPS to develop some new TOU programs, and then you're going to have all of this participation from currently non-participating SPS customers. Is that right?
I am assuming that because the basis is in the Brattle study that does show that when you have these types of programs, then that's the type of participation and savings that you will get. So that's why I have that included in my model.
Do you know what the percentage of this purported 25,000 megawatt hours savings is of the particular customer load?
Oh, well, it corresponds to about 20 megawatts. So I don't know the full load, but it's 20 megawatts. So that is a fraction of the total load.
Yeah, I just wondered what kind of fraction it was. So you're looking at the savings, but I'm wondering how I would put that in perspective to are the TOU customers actually going to be able to save 5% or 3% of the total customer class usage?
I don't have the number of the total to do just that simple math, but I can get that back to you pretty quickly after this.
Ms. Lees, why don't you consider that a bench request? I'd like to know the purported savings and how that translates into actual an actual percentage of the usage.
And
Sure.
Ms. Hearing Examiner, one point again is that we're assuming those 20 megawatts. It's not that they're gone, but they're just shifting from the on-peak to the off-peak.
Yes, I understand that, sir.
Okay.
Thank you for that clarification. Thank you, Mr. Getko. Go ahead.
can I just pause for 1 second? On my screen, Mr. Rowling is frozen in a static image, and I'm dealing with it, but it's a little bit strange to have.
Oh, that's
movement.
really unfortunate. I hope it's not a horrible pose. Gosh.
No,
I'll turn off and on my video. Hopefully that can.
Yeah, we'll live with it, but I thought I'd give it a shot for a second.
Is that any improvement?
No, you've turned into a black square now.
That's terrible.
Okay, I don't need to hold everything.
I apologize. Gosh, sorry.
No problem. We'll move on, and that's just fine. So I'd like to refer
and you
you.
realize, hold on, Mr. Getko, you realize, Miss Lees, that, I mean, that's part of the responsibility of the attorney, is to make sure that your witness has functioning audio and video.
Yes, I understand, Your Honor. It was functioning when Mr. Rowling first started testifying, so I don't know what changed. Would you like him to exit the Zoom and re-enter?
Why don't we try that to see if,
Okay, I'll
if,
try that
if
quickly.
that will capture him, capture his image.
Did he already exit?
I don't know, Mr. Rowling, did you leave? He's still on screen, or his name is. I don't show that he's trying to be readmitted.
That's what I get.
There he is.
Well, fingers crossed.
There you are. Okay, you're back. Go ahead, Mr. Getko.
Great, thank you for that. Much better. So I'd like to welcome back, Mr. Rowling. I'd like to refer you to attachment SDR1.
Okay.
Which was, I believe, to your direct testimony.
I have it in front of me.
If we go to page 2 and on row 34, my understanding is that shows the time of use customer energy price shift, and that those benefits begin in year 2027. Is that correct?
That's correct.
Do you know in what year SPS would need to file a time of use rate proposal with the commission in order for customers to be enrolled in shifting energy usage by 2027?
I do not know the lag between, when that is filed and when we would have that to be realized.
Because we've been talking about how some of the data is needed to understand how that shift would actually occur, would SPS need to pilot or test a time of use rate prior to filing a time of use rate proposal that would provide those benefits in 2027?
I don't know if a pilot would be required or if we could get that data just from the AMI meters themselves at this point. So I don't know that a pilot would be required.
Okay. If you didn't have a pilot, would you depend upon behavior patterns in other jurisdictions of Xcel Energy to understand the amount of shift that would occur for a given rate?
I think potentially you could look at other jurisdictions and see that. I think potentially, since we would have AMI meters, given results of this case potentially, that we could look at the data from those AMI meters and for our existing customers as well. So I think there's a couple sources that we could use to determine the optimal time of use program.
And I think we touched on this just a little bit ago when Madam Hearing Examiner asked you a question and you spoke to the total benefits for customers for AMI being about 2% of the total benefit. If I understood that correctly, can you confirm that there are no benefits prior to 2027 that are a result of customer-facing programs that utilize the AMI meter technology? And by customer-facing, I mean programs that are specifically offered to customers.
Your Honor, I'm just going to object to the form of the question. Mr. Gitka said the total, the 2% benefit of AMI meters to the total percentage of AMI meters. I'm not clear what he's asking, and I'm just going to request that he maybe restate the question.
That's fair. And maybe Mr. Rowling can clarify. I understood when you were speaking with the hearing examiner that there was a question as to the total benefits of AMI and the amount that was realized due to customers shifting their load, and that you made a statement that that was 2% of the total benefit of the AMI program. Is that a correct understanding?
That is correct. And let me clarify that a little bit. It's 2% of the quantified AMI program in my model.
Okay. Maybe I just simplify this. Can you confirm then that there are no benefits prior to year 2027 as a result of customer-facing programs that utilize the AMI meter technology?
Well, I want to be clear about what, and I have this in my direct testimony. I explained it very thoroughly, that I am seeking to capture quantified benefits. There are many other benefits for AMI and different programs that I don't necessarily, because of the uncertainty around those. One example could be customer satisfaction. I'm not quantifying that and including that in my model. So there could be other programs where there are customer benefits. In my model, I do not have any benefit quantified prior to 2027. So that, just that clarification.
Oh, and one little you do have benefits that are quantified prior to 2027, but nothing prior to 2027 that is quantified for customer-facing programs. Did I understand correctly?
That's correct.
Okay. What you started to speak to was my next question, and I have it. Well, actually, since we're here on the benefits, let me go to this. When Mr. Luth testified, we heard testimony that, and I believe from Ms. Trammell as well, that SPS has a high load factor and that peak shaving may not be as important as in other jurisdictions. So staying on attachment SDR1 here on page 2, where we see the benefits displayed from the time of use rates as well as critical peak pricing. Is this fact of the high load factor accounted for in the benefits that you claim for the time of use rates?
How I Yes, in that I am only including residential benefit for that time of use shift. So that's why it's tucked in there. Now, line 33 that talks about critical peak pricing, I do have that. However, as you saw in other attachments, that is considered just a potential add-on later. We currently do not have any critical peak pricing, well, I'm not aware that there is a plan for critical peak pricing at this point, but I put that in the model as a potential option down the road. So that would, and that is more directly impacted by your statement of the utilization of the system.
And would that critical peak pricing apply to the industrial customers in the way that it's been theorized in your analysis?
In my model, I am only doing, these are only numbers associated with residential.
Okay.
So I'm not capturing anything beyond residential impact.
Okay, so including for the critical peak pricing, that's only applied to residential as well, if I understood correctly.
Yes.
And then one thing you said there, you said that there isn't a plan at this point for critical peak pricing, and so it's theorized that something would be an add-on, I guess is what I just wrote on.
Can I clarify that? I did say I am not aware of a plan. So,
okay.
Yeah.
Absolutely fair. That just leads me to ask for the time of usage customer energy price shift in line 34. Is that based off of the existing TOU, or is that based off of an add-on TOU of which you are not yet aware?
And I believe I answered that before. That is based on a Brattle study of an assumed potential more optimized TOU. So that is not based on the existing TOU program.
Okay, thank you for that. Thanks for returning to it. So you had mentioned unquantifiable benefits, and you pointed out again that those benefits aren't modeled in SPS's benefit cost assessment at this point. Do you anticipate that in the future SPS will conduct an evaluation to assess whether any of these unquantifiable benefits are realized?
I don't know.
Do you ever try to quantify? Well, that's a stupid question. Will you ever make an attempt to change these unquantifiable benefits to quantifiable benefits in the future?
In what context?
Well, perhaps in a future grid mod filing, for example, when you again need to justify your investments and
I'll answer it generally.
Okay.
In the risk department, we try to capture whatever has, I guess, a reasonable amount of certainty in terms of and quantification and justification for those numbers. So if there was a future grid mod assessment where we're evaluating benefits, and if there was more clarity or certainty around certain benefits and we had justification to include those, we would include those.
Okay. And what is there like a methodology that exists in the industry for that helps to quantify those? Like how do you go about if they became certain enough and they were unquantifiable, how do you then quantify them? Is that a question that can be answered?
That's super speculative. I mean,
Yeah.
I don't know. Now, just to step back, how we approached this, we did look to other industries, like, and I have that in my testimony, like Ameren in Illinois, and how they and which benefits they look to quantify, and we made sure that we could, that we had a reasonable basis and framework to start with. So we would go and look out to different utilities and different industries and different ways of quantification. But like I said, it's very speculative how that could be done.
Fair enough. Okay, moving along. You basically, in your analysis, have two cost benefit analysis. One for AMI, which includes the FAN network components, and one for FLISR. Is that correct?
That is correct.
And would you agree that the majority of both benefits and costs are included in the AMI/FAN analysis?
The majority of costs and benefits are within the AMI analysis.
So then I just want to go to, we're still on SDR1, but go back to page 1 instead of page 2.
Okay.
And now I'm on line 43. Oh.
Okay, I'm there.
Okay.
That's not my dog. I promise.
Sorry, it's mine.
Okay.
I was about to say, I do not have a dog in the office with me today.
Someone shut his door.
Theme of the day, puppies and dogs.
Miss Hearing Examiner, do you see that we are looking at your screen? We're viewing your screen now.
Yes, hopefully I've got it on the right page.
Okay.
We're seeing your background. I think we're seeing like a Machu Picchu style.
Oh, that is Machu Picchu, as a matter of fact. Okay, let me try that again.
All right, that's where we want to be. And,
Well, guess that's relative.
I can see it. Line 43.
Yeah, line 43, where it's total O&M costs. What I'm seeing there is for 2022, a total of O&M costs of $341,971. Is that correct?
That's correct.
And now we're in a position where, would you agree that this grid modernization program will not be approved in 2022?
That's true.
So now just, if we go to 2023, you estimate O&M costs of $718,521. Is that correct?
That's correct.
And just walking through this, those costs then increased to over $1.7 million in 2024, and then to over $2.2 million in 2025, correct?
Correct.
Okay, so that's the review of the cost. Now I'd like to...
Can I clarify?
Absolutely.
Just so that it's clear, these are not costs that are used in rate making. These are only costs. I am seeking to capture all the costs of the project to do an evaluation of the benefit over cost. These numbers were determined, I believe, from June budget, a June budget of 2022. So these absolutely could have changed. There's some difference here. The other note I want to make is you can see the run out of those O&M costs all the way through the end of life of this project. Well, we don't, within our budget systems, have that many years within that. So I'm trying to capture the total cost of this this program, this asset, over that entire 20-year life to make a good assessment.
Okay. Okay, thank you. Okay, now I'd like to turn to the savings side of the equation of the benefit cost analysis. So can we turn back to page 2 again?
Okay.
And is it correct that the O&M benefits are shown on line 24?
That's correct.
So in 2024, the company estimates total benefits of $737,330. And that figure then increases to over $3 million by 2025. Is that correct?
That's correct.
And then speaking to that whole life of the project, according to your study, that the benefit increases each year over the next 20 years, correct?
Correct.
And is it correct that about half of the total benefits shown on line 24 relate to reductions in meter reading costs, and about half relate to other cost savings?
That's correct.
And those meter reading costs reductions are on line 7, correct?
That's correct.
Have you been aware that under the company's proposal, the O&M costs would be recovered through the grid modernization rider, but those savings would not be passed through to ratepayers except through a base rate case?
I am aware of that.
I think you might
You're
have
about at 10 minutes, Mr. Getco.
I think I'm done. I'm just double checking one note. Yeah, I'm done, and I just want to say thank you, Mr. Rawling, for answering my questions. Thank you, Madam Hearing Examiner.
You're
Thank
welcome.
you, Mr. Getco. Ms. Lynch, I believe that you reserved time for questions for Mr. Getco.
Uh-oh.
I'd appreciate that.
Sorry. Yeah, we're going to ask Mr. Getco. Why am I not seeing? Need to resize. Ms. Lynch, go ahead.
Okay, thank you. And just for reference, we're going to be looking at that same cost benefit analysis table that you had pulled up. I don't know if.
Okay, I'll pull it back up.
Okay. All right. Good morning, Mr. Rowling.
Good morning.
I'm Kara Lynch, the attorney for the Coalition for Clean, Affordable Energy. And I, before delving into the prepared questions, I would like to build off of and learn a little bit more regarding Mr. Getko's question about your role at SPS. Can you state your role again? What position you hold?
I'm the Director of Risk Analytics.
Okay. And I'm just curious, what risks might you analyze?
My primary role is I am in charge of enterprise risk management for the organization. So I look at basically the top potential risks for the entire company. That's primarily what I'm responsible for. I have been brought in to evaluate and develop a cost benefit analysis for this, as I guess I would say it in gratuitous quotes, an objective voice or measure to ensure that the benefits for the customer exceed that of the cost to the customer for this program.
Okay. Is one of the risks that you consider climate change?
Climate change is a risk that we look at the enterprise level.
And how do you break that down? Because climate change encompasses many different risks.
Your Honor,
This is going, yeah.
I'm just going to object because I'm not sure analyzing the risk of climate change is within the scope of Mr. Rolling's testimony in this case.
Mr. Rolling, and as part of your evaluation in this case, did you evaluate climate change?
I did not.
Do
Ms.
you?
Lynch?
Yeah, I asked that question because utilities.
I don't want you to testify, Ms. Lynch.
I'm not. I'm asking because the advanced metering infrastructure is meant to. One of the reasons for advanced metering infrastructure is to abate the risks of climate change. Would you agree, Mr. Rawling?
I'm going to object again to Ms. Lynch's question that Mr. Rolling testify on the purpose of advanced metering, which is outside the scope of his testimony filed in this case. Mr. Rolling did clarify that his testimony addresses a cost-benefit analysis, and that analysis is what his testimony addresses.
Well, he addresses the benefits of the AMI program, so I'm going to overrule the objection. Answer if you know, sir.
Could you repeat the question, please?
One of the benefits of advanced metering infrastructure is that it abates the risks of climate change, correct?
I do believe that that technology could potentially abate the risks of climate change. At this point, the impact and the uncertainty around that, I am unaware of. And so that was not included in, again, I'm really looking at, and I'm very clear in my direct testimony, quantified, benefits that we're able to capture for this program.
And one of those quantified benefits is reducing peak load, correct?
That is correct.
Okay. Could you please turn to page 38 of your direct testimony?
Yes. Okay, I'm there.
All right. And here you provide a table of figures of AMI benefit cost related figures. Can you please let me know when you are to table SDR 9?
I'm there.
Okay. In the fourth row down, you list other benefits.
Yes.
What are these other benefits?
Those other benefits tie to attachment 1, my SDR1, and you can look at the lines 25 through 36, and those are broken out, which includes the time of use, customer energy price shift.
Okay, and so you're at SDR1, I assume.
Yes.
Great. So, line 34 is the line that you were referring to, time of usage, customer energy price shifts?
Yes.
Okay. Did SPS use the Brattle study for Northern States Power and SDR5 as the source for this line of benefits?
Yes.
And can you
Let me caveat that. Let me caveat. We used that as a foundational source, and we normalized it to the size of the New Mexico system.
Okay. Can you describe which scenario and the associated dynamic rates from the Brattle study SPS used for its cost-benefit analysis?
Yes. Attachment 5, which includes the Brattle study. If we're going to have to, let me find it. Foundationally, it's on page 68 of my attachment SDR5, and we use the residential TOU potential megawatt hours at the generation level savings. So that chart is really the basis of in simple terms, that's the
page?
basis for page 68. That table. Oh, and yeah, that's my page 68 is different than that page 68, unfortunately. We keep
Madam
going.
Hearing Zimner, it's the page number at the bottom of the document that he's looking at.
Oh, thank you.
Okay, not the top. No. There we go.
There it is.
Okay.
So the lines residential TOU opt in and residential TOU opt out were the basis of that benefit calculation.
Okay, thank you. Thanks for that description. And can you describe how SPS used that scenario to calculate the benefits in SPS service territory?
We used, so this analysis was based on our NSPM, Minnesota service territory. So we took these, and I used the TOU opt-out benefit as a high-level potential benefit. And then I basically ratioed the total generation aspect with Minnesota to bring that, like you can see in 2024, the 155 megawatts that ended up coming down to roughly 20 megawatts to normalize that to New Mexico.
Okay. So, in other words, was the benefit calculated in this cost benefit analysis based on a default time of use rate?
it was based on the TOU opt-out program.
Okay. I appreciate your answers. And
Could I make
Mr. Wall,
one clarification, because of just to put things into context for the hearing examiner? We ran it as well, the opt-in or the opt-out. The difference being, if you go to the overall cost benefit analysis, it was 1.08. If you use the TOU opt-in, it would move to a 1.06. So the opt-in program does show less benefit for the customer, but it's small in terms of the overall ratio change.
thank you for that context. Those are all the questions I have for you, Mr. Rawling, and hearing examiner Hurst. I'm finished.
Thank you, Ms. Lynch.
Yep.
Mr. Pagatko, I believe that staff also reserved time for questions for Mr. Rawling.
We did reserve a
Not
little
Mr.
time for
Gay.
Mr. Rowling.
Go ahead, sir.
Thank you. Mr. Rowling, good morning. How are you?
Good morning.
I think I might know the answer to this question, but I'm going to ask it anyway, just to make sure I'm clear. You were just talking about with counsel, the quantified benefits in association with shifting load that I understand would be appreciated by people who get the AMI meters. Is that a correct summation of, generally speaking, of what the discussion was covering?
Yes.
What if people go with the opt-out meters? Would they still be able to enjoy those same quantified benefits if they get into a load shifting program, pursuant to the time of use rates that we've been discussing?
My analysis shows that only those with the AMI meter provides that benefit.
And the AMI meter provides that benefit by virtue of what? Real-time tracking of use patterns and when they're using or not using electricity under the TOU.
That could be many of the possibilities that the customers could use that to achieve that savings.
But a customer who opts not to have an AMI is just then out of luck in terms of realizing any of those benefits, if I understand you correctly.
Yes, according to my model, that is correct.
Okay, thank you. If you bear with me, I'd like to direct your attention back to that popular document that's attached to your direct testimony, SDR1.
Okay, I'm there.
There in the next to last column on page 1, where we're talking about costs, if I'm reading this correctly, the total costs for what SPS is proposing in this case for the grid modernization is $70,874,004. Is that correct?
No, and as I stated previously, this is what I am using as a total cost of the program for 20 years. Okay. This is not what's being proposed for rates.
Okay. But the total cost of the program for 20 years, I thank you for framing that more correctly. Did you testify or did you provide testimony in the first grid modernization case that we had here? I believe it was case number 21-00148-UT.
Yes, I did.
And if I remember correctly, I think you had a similar attachment as what we see here in SDR1 to your testimony in the first grid mod case. Am I correct in that?
Yes.
Do you recall what your total costs for the old grid mod case were for the 20 years?
I don't recall that.
You remember if it was more, about the same, or less as what we're seeing here in your current SDR-1?
I don't remember.
Okay, fair enough. Do you recall the circumstances that led to the dismissal of the first grid mod case 21-00148-UT?
I don't recall the specifics.
Do you remember whether or not one of the reasons touted in support of SPS's motion to dismiss the first grid mod case centered on concerns over cumulative rate impacts for residential and small business ratepayers of SPS?
I don't recall that being specifically outlined.
Okay. Are you aware of the order that was issued by the commission in this current case, 22-00178-UT, that asked SPS to satisfy certain questions in connection with the application they filed in this proceeding?
I am aware that was part of this case.
Were you involved in the formulation of any of the responses to those specific issues raised by the commission in that order?
My role has been, sorry, I was getting some feedback. My role has been to quantify any change in the costs and benefits, but I wasn't part of that decision process.
Okay. Well, then, speaking to your role and what you've done in this case in quantifying costs and benefits, was your analysis governed in any way based on sensitivities to cumulative rate impacts to residential and small business ratepayers of SPS?
In the fact that I wanted to quantify conservatively the benefits that all customers, well, not all customers, that residential customers would get from the program and their full cost stream across the 20 years to ensure that the overall benefits to the customer did exceed the overall costs to the customer over that life.
You're aware that SPS has recently filed a new rate case, correct?
Yes.
And do you understand that that rate case number is currently docketed as 22-00286-UT, correct?
Yes, if you say so. I don't know for sure.
Okay, will you be offering any testimony in support of that case?
I will not.
Was your analysis that we see here in this case, especially as reflected in SDR-1, weighted or affected in any way by the requests that SPS is advancing in its new rate case?
This analysis was done in June 2022, so that I would say no.
Okay. All right. Well, thank you very much for those clarifications and your time. And I think I only reserved about 7 minutes for you, so I don't want to overstay my welcome. I pass the witness, Madam Hearing Examiner. Thank you.
Thank you, sir. I believe that's all of the participants that reserved time. And I haven't heard that anyone else has questions. So I have a few questions for you, sir. I wanted to just get some clarification, though, on something that just came up this morning. And I think it had to do with I think it was your page 68 questions with regard to that, but did I hear you correctly, Mr. Rowling, that you said that you did not include in your analysis capturing the TOU benefits? Did I hear you correctly that you didn't capture any opt-out meter potential savings for TOU?
I actually captured the opt-out TOU program in my analysis that resulted in the 1.08 benefit over cost ratio. So I used the opt-out, the more, I guess, I guess the bigger TOU impact potential in my analysis. I used the opt-out actually in the
Oh, you
analysis.
did? Okay. So, because I thought I heard you say that the opt-out meters couldn't utilize TOU rates.
Correct. And I guess to clarify that, the two different streams are an opt-in and opt-out, meaning that's what the customer chooses. So if it's a TOU opt-out, it means that they are on a time of use rate unless they opt out. And the TOU opt-in is they are only on the TOU rate if they opt in. Neither one actually captures a benefit for those customers that have a opt-out meter.
Even though the opt-out meter functionally will allow for TOU rates, correct?
Yes, that's what I'm aware of. Correct.
Okay. Because I thought that's what I heard from Mr. Nickel yesterday, is that the opt-out meter will also allow for interval data capture and will also allow for TOU rates. Is that correct?
That is correct.
Okay.
The analysis that Brattle uses assumes that the customers that have an AMI meter and are a part of a TOU program then have the visibility in order to make those changes so that you can get that level of impact. So I guess that's the difference. If a customer has an opt-out meter, they may generally know, oh, it's more expensive during this time, than other times, and they can make changes, but they won't have the visibility to really be able to optimize those changes for them as a customer.
But it doesn't mean that those with the opt-out meter won't be contributing some benefit if they utilize TOU rates.
Potentially, correct. Yeah.
Hang on just a second. I think we've lost our... Anybody see the court reporter?
Yep, I can see it.
I'm here.
Hi, Allison. Were you gone for a minute?
I was not.
Can't hear you.
I'm here.
Madam Hearing Examiner, we can hear Allison. Can you hear
I
me?
can also hear Allison. Yes. Yeah.
I don't see Miss Beatles.
Okay, can you hear me?
Yes.
Okay,
Yes.
so did we have a glitch?
I think you did.
It was me? Somebody, I think the problem was, I thought that you were calling me.
I was not.
Okay. Bad phone.
It might have been Miss Beatles.
Is she,
I don't see her.
okay. Ah, thank you for the chat there, Miss Lees. It was me. Okay. All right, so we're good. I don't see that she's asking to come back, so we will go ahead. And I'm sorry, Mr. Rowling, I was looking at your testimony, hoping for a clarification. You can look at page 22 of your direct testimony. You're answering the question. I'm on 24. Answering the question posed on page 23, line 15. Please further describe unquantified or unmonetized benefits. And one of those that you set forth at line 1 of page 24 is a greater hosting capacity. Is that correct?
Yes.
What is that?
So, and that I believe that was described by Chad Nickel, that we could have, because of the optimization, there's an opportunity to have additional DER and those types of programs because of more insight into our system.
Okay. And Mr. Rowling, as part of your evaluation of risk, does it include more than financial risk?
In which context? In my normal job,
Yes.
my other role? Yes, it includes, full risk assessment.
So physical risk, financial risk.
You
Is there
got
some
it.
other kind of risk?
Sure, reputational, all kinds of different aspects of risk. Yep, we try to look at all of that.
Okay.
And to clarify, I was not asked to do a risk assessment on this program. I was asked to do a cost benefit analysis. So it looks very different.
Okay. Sir, on page 26 of your direct testimony, you're continuing to answer the question posed on page 25 at line 7, what are the key costs and benefits of AMIs? And on page 26, line 3, you identify other labor for operational support. Do you see that?
No, I can't find it. Which page?
Page 26.
Okay.
And line, the sentence
Oh,
begins.
yeah, I see it.
Okay. Can you
All right, let me
give me
yeah, let me get the
examples?
Let me see. Yeah. Yeah, and that can be, yeah, and I'm going to go back to my attachment 1. There can be other operational support can be supporting the communication network. Those are ongoing O&M costs. Also, we do have ongoing IT O&M costs to support that, and that can indirectly impact, I guess, operations in terms of keeping up our IT and software. But I would say primarily that an example of that is just the ongoing sort of communication costs associated. Other O&M, and maybe this is really specific, but could be, no, I mean, I think that's probably it, actually.
Because isn't supporting FAN and IT, isn't that supporting communications under that category that you already listed?
That's tucked in, yeah, within the IT.
Okay. Okay. So are you double counting there, or?
No, I mean, we're taking the full budget, the O&M budget that was given to us to capture the total cost. If I'm double counting, then the ratio would even be better, because I'm trying to.
No, I meant double
customers, but
double counting in your characterization, not in your actual numbers.
And maybe that's the case. Yeah, I'm not quite sure.
Okay. Sir, on page 37 of your direct testimony, the question posed at line 20 through 22, overall, how would you characterize the cost benefit budgeting assumptions in this model for each component of the grid modernization initiative? Begin your answer at line 23. And then on line 24, continuing, you say, I would characterize this model as a conservative representation of estimated costs and benefits. Is that correct?
That's correct.
Okay. And why are you characterizing this as conservative?
Conservative in terms of from the customer's perspective, because I'm including not only the costs, that are presented in this case, but I'm looking at the costs to the customer across the entire life of this program, the life of the asset of 20 years. And in all of this analysis, that if there was ever a point where I would, I guess, need to lean with the numbers in terms of cost, I made sure that I captured sort of the higher end of potential costs to the customers. And then on the other side, with the benefits, I made sure that I could only, those benefits that were, I guess, had more certainty and could be quantified, those are the only benefits that I included. As I said, it is an example. I didn't try to capture a customer satisfaction. I didn't try to more of those nebulous benefits. I didn't include those. So I'm including sort of the hard potential customer benefits and then the most costs, just to make sure that I am, with those two parameters, to make sure that it's still beneficial to the customer. And that's why I said it was conservative.
Very well, sir. Thank you. Those are all the questions that I had for you. Ms. Lees, any redirect for your witness?
No redirect, Your Honor. Thank you.
Okay. Anything further
Yes, Madam
from
Hearing Examiner.
the parties? Mr. Gatko?
Yeah, you all just discussed this, the cost benefit analysis and the conservative nature of it, the 20-year calculation. Did I understand, is it correct that some of those calculations were done based off of a Minnesota baseline?
Only for the time of use, but only that Brattle study, because we did not have that, they did not do that study for SPS in general or New Mexico.
So have you heard the extensive testimony on how it would be difficult to design a time of use rate to go along with this application due to a lack of knowledge on an interval basis for SPS's New Mexico territory?
I guess to clarify that, are you saying that the challenge currently to develop that based on our current data and assumptions?
Yeah, that's the testimony that I was referring to.
Yes, I've heard that.
How do you reconcile that with basing your cost benefit analysis on data from Minnesota?
Objection, Your Honor. Mr. Rowling did not testify that he based the entire cost benefit analysis off of Minnesota data.
Yeah, I apologize for not having that perfectly clear. The portion of your cost benefit analysis, Mr. Rowling, that was based off of Minnesota, how do you reconcile the accuracy of that? And it's with respect to the time of use analysis, is my understanding. I just heard you say. How do you reconcile basing some of your cost benefit analysis with respect to time of use rates with the testimony that we've heard that New Mexico territory is unique and information isn't available?
We looked at, so we had a couple states with the Brattle study to look at. We had Colorado and we had Minnesota. And back to my conservative point, that the data that we had for Minnesota and that Brattle study did show a lower potential time of use savings than in Colorado. So we wanted to make sure that we were more conservative there. We also then, as I said, we normalized it to the size of New Mexico. And given that the overall, of the overall benefit, the time of use piece for this program was estimated to be about 2% of that total benefit. We felt that that at least gave a reasonable number to potential savings there. So just, by taking, I agree, there are differences in the NSPM, the Minnesota territory, and the and New Mexico, but by at least scaling it back and not having that benefit realized, until I believe it was 2027 in the model, I felt that we were conservative enough to be able to include those numbers.
Okay. Yeah. There's some
Okay,
idea
Mr. Gatko?
there's some idea then that individuals in different states have some degree of similar behavioral patterns. Then, otherwise, you wouldn't be able to trust that application to New Mexico of the Minnesota and Colorado numbers. Is that fair?
I would say overall as a system, I think it's fair to say there's some general similarities there to be able to capture that benefit.
Thank you, Mr. Rowling.
Thank you, Mr. Gatko. hearing nothing further.
I have one just follow-up question, Your Honor.
Okay.
Mr. Rowling, why is it preferable to conduct a conservative cost-benefit analysis for these programs?
I almost should call this as like a worst case scenario for customers cost benefit analysis. I want to make sure that, even if other benefits aren't possible, or if things are uncertain or that type of thing, at the fundamental financials in terms of costs and benefits for the entire length of this program is still beneficial to the customer in the long run of that program. So that we just want to make sure that it still makes sense, that this program benefits the customer, that it won't cost them more than the benefits they receive in the long run. Basically, almost as a worst case scenario.
That's all, Your Honor. Thank you.
Thank you. Very well, sir. Thank you for your time, and you're excused.
Thank you.
All right. I think it's probably appropriate at this particular point to take a brief recess. Why don't we take a 10-minute recess? I have
Madam Hearing Examiner,
sir.
I just wanted to provide a piece of information. My witness, Andrew Teague, tells me that he has an appointment at 1 o'clock our time that would last about 1 hour, during which he would not be available. So I don't know how that plays into the progression of the case today, but I wanted to pass that along.
I believe Mr. Teague will be after Ms. Trammell gets recalled, and I'm not going to have many questions for her, so I would anticipate that will not be a problem,
Okay.
Mr. Bartel. But I thank you for bringing that up. So I have 10:26, so let's say 10:25. Let's come back at 25 till, and we'll hear briefly from Ms. Trammell. Okay. Thank you. Okay. We are back from our recess. And Miss Hardy, the only one she tried to get in before when Mr. Rowling was here, but I don't see Miss Trammell trying to get in.
Okay, Madam Examiner, we are making sure she's on right now. Just give us 1 minute.
There she is. Hello there, Miss Trammell. Miss Hardy?
We are asking Ms. Trammell to unmute and turn on her video, please. Ms. Trammell, we can see your name, but we can't see you, and it looks like you're muted. There she is.
There you are. You're in the dark.
Apologies, Madam Hearing Examiner. I was getting a note from Zoom that Can you see me now?
I can see you now.
And can you hear me
Okay.
apparently?
I can hear
Apologies,
you
Your
now.
Honor. I was getting a notice that
Okay. All right, Miss Hardy. We are resuming from our recess, and pursuant to some questions I had for Mr. Fetters, I believe yesterday, about the company's proposed procedure for the filing of its annual, I'll call it, GMR revenue and rate. Mr. Fetters could not answer those questions, and SPS indicated that Ms. Trammell could provide some illumination on that. Is that correct, Ms. Hardy?
That's correct, Madam Examiner.
Okay, go ahead. I would just remind you, Ms. Trammell, that you're still under oath. Do you understand?
yes, technically, I think you released me yesterday. I'm happy to be sworn back in, or we can just assume I'm still under oath, whatever you prefer.
Okay. Allison, what should we do?
It's up to you. I can swear her.
Okay, swear her again. Thank you.
Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Go ahead, Ms. Hardy. Do you have questions prepared, or do you want me to ask mine?
I do have questions prepared, Madam Examiner.
Go ahead.
Okay, thank you. Ms. Trammell, SPS's proposal in this case involves 2 annual filings. Is that correct?
It does.
Okay. And is the first one going to be made in August of each year?
Yes, that is our proposal on or before August 1st.
Can you describe what will be included in the August filing?
Yes, the intention of this August compliance report is to provide a host of information to the commission staff, and interveners in this proceeding. The intention would be that it's filed in this proceeding, so it'd be also available to other interested parties because it would be in the docket. We would expect to include a bit of an executive summary in that report of the activities undertaken the prior calendar year, as well as report on the numerous reporting metrics that SPS has agreed to, proposed, or established over the course of this proceeding, again, for the prior calendar year. We would also provide information on actual costs for the grid mod projects that have been placed in service in the prior calendar year, and report on the actual GMR revenue, or the revenue collected through the GMR rider if it was in place in the prior calendar year. So those would be the four broad categories. Like I said, with regard to the two true-up components, that would be the actual information related to the GMR project, grid mod project costs. There'd be a comparison of those actual costs incurred in the prior program year to SPS's estimates of the costs for that particular year as presented in this proceeding. I think that's important to include in the compliance report because the grid mod statute establishes that costs that are at or below the commission approved cost estimates for the grid mod projects are presumed to be reasonable. And so on the grid mod revenue, or the GMR revenue side, we would also be tracking actual revenue collected in the prior calendar year to the revenue estimates that we'd included in the derivation of the applicable GMR rates. And so the true-up process would include both a true-up of costs and revenue collected under the rider. All of that information on the costs and revenues and the associated true-ups would be included in the October 1st advice notice filing that SPS proposes to make.
And Ms. Trammell, is the October filing the second annual filing that would be made each year?
Yes, on or before October 1st.
Can you describe what would be included in that filing, please?
Sure, it'd be filed in the proceeding, served on the same parties, and provided to the commission. We would expect to introduce those true-up calculations, both for the project costs and for the revenue collected, and present the updated revenue requirement for the next calendar year. So we would actually calculate what the GMR rates would change to for the next calendar year and identify any of the true-up amounts, if applicable, from an earlier program year. So that would be, as I noticed, an advice notice filing, which I understand if in New Mexico, if parties protest, the commission can set that protest, or excuse me, make that protest a new proceeding or a new case number, and then if needed, adjudicate that proceeding to resolve any protests. And if that were the case, that new adjudicated proceeding would resolve before the GMR rates would change on a going forward basis.
Thank you. And Madam Examiner, those are the questions that I've had for Ms. Trammell on the filings proposed to be made by SPS. If it would be helpful for your honor, I believe Ms. Trammell is also prepared to address briefly the circumstances at Piesco regarding the time of use rates that were discussed yesterday.
Oh, okay. Let's, before we get to that, I guess I would like to know Ms. Treble, the August 1st reporting filing, the information that it's going to contain is going to be offered in a in a written way that includes, is it going to include some kind of affidavit or verification or testimony, or how did you envision presenting that information?
I envisioned the August filing as a report filing. So with not envisioning testimony per se or an affidavit, but a summary description of the projects undertaken in the reporting year, as well as those comparisons of costs. And the real intention here in the August filing is that the information is provided so parties can see any differences from what actually happened in the reporting year to what we expected. And that would serve as a preview of sorts, if you will, for the advice letter filing in October. I consider the August report to be informational only. So in addition to the cost components and the revenue components and a preview of coming attractions on any true-up calculations that'll be necessary, it would detail those reporting metrics. So I don't envision that we'll just, have a list of 30 metrics with no narrative, right? So we would have some narrative in the report to provide some context around those reporting metrics. I think especially in the first couple of reporting years, or certainly while deployment is still ongoing. But then the affidavit or supporting testimony would come into play in the advice letter filing in October. And again, I think that's the appropriate place for that kind of evidence from the company, because that would be an advice notice filing, and the commission would be evaluating under the grid mod statute our actual costs compared to estimates presented in this proceeding.
And back to the August filing, which you're referring to as an informational filing, which you indicated is going to have actual cost, actual collections, any other agreed upon reporting items. With some type of summary and descriptions. Will there also be an attribution to who's providing that information?
Can you clarify?
Well, for example, in your number report, is it going to be signed by Mr. Fetters or Mr. Luth, or?
Oh, I understand. We generally, when we make compliance reports, we may have various representatives of the company from a regulatory affairs perspective, or perhaps legal counsel.
Okay. And with regard to the October 1st,
the data, we're not opposed to providing something like that.
Okay. And as far as the October 1st, which you've indicated is an advice notice filing, you serve that upon the parties to the case. I think generally anything that deals with the rate, you're going to serve on the prior rate case people on the COS. You're going to have your updated revenue requirement, and your true up information, your proposed new rate, and your request to have the new rate go into effect, I'm assuming at the beginning of the next calendar year.
Yes, January 1st.
And you say that particular information is going to be verified or attributed by affidavit or testimony. Is that correct?
We can provide that verification there as well. I think the testimony would also be necessary if there are variations in the actual costs compared to the estimates. So
Okay.
kind of a two-part verification in the advice notice filing, as opposed to more of a verification of actual data in the August compliance report.
And what you would envision in this particular proceeding is that it would go into effect as any other advice notice within 30 days, unless the commission suspends it.
That's correct. I believe this is a similar process to what the commission authorized in our transportation electrification proceeding.
But you don't foresee providing any notice to your customers that the rate's going to change.
No, Your Honor. It's my understanding the commission rules require noticing customers for the establishment of a new rate. Here, the GMR presumably would be authorized in this proceeding. And so these subsequent October advice notice filings would be updated rates or revised rates, but they would not be new rates.
So even though the rate potentially could change, including doubling, depending on what the costs are, it's SPS's position that once the rider has been authorized and notice was given of the initial rider process, no notice is necessary, no matter how long the rider might last into the future, 10, 20 years. Is that correct?
That's correct. And that's based on, again, our understanding of the commission's rules and consistent with the commission's established process for rider adjustments for our TEP.
Thank you, Ms. Trammell. As indicated by Ms. Hardy, there was also a discussion yesterday with regard to the Colorado, the AXL Colorado utility, that some questions weren't answered, and it's my understanding that you can provide some information on that subject also.
Yes, I can. I was the RVP in Colorado for 4 years, from June 2018 through June of this year.
And what can you tell us?
You know, I think there was a long process to establishing time of use rates in Colorado. And so for purposes of evaluation of potential new or amended time of use rates for SPS, or even the potential transitioning all of SPS's residential customers to a default time of use rate, I would just offer to Your Honor that, you know, that process in Colorado, which did end up with a default time of use rate for all of our residential customers, was a very involved and long process. So, for example, PSCo originally proposed a residential time of use pilot in 2011. And so here we are about 11 years later, now in the middle of implementation and transition of our residential customers in our Colorado service territory to a default time of use rate. A lot of the work picked up after that 2011 pilot. There was about 4,000 participants in that 2011 pilot. So that's about 1/3% of PSCo's residential customers. So relatively low participation in that pilot. As part of a 3-case settlement, as we referred to it in the jurisdiction in 2016, a more robust pilot framework was established. We refer to that as the RETOU pilot in Colorado. There was also an RDTDR, which was a demand rate for residential customers that was piloted as well. approval for those pilots were received in that 2016 timeframe. So those pilots ran from about 2017 through 2021 with the RDTDR, or the demand rate pilot, going through all the way through calendar year 2021, I recall. So we had, I think it was discussed yesterday, that the pilot targeted several thousand participants. We did see pretty minimal participation, certainly more than the 2011 pilot. But for example, our targets for customer participation in the RETOU pilot in Colorado was between 10,000 and 30,000 customers across the 3-year time frame for the pilot. We received or had about 5,800 participants in the time of use pilot. So, pretty far below what we had marketed to and tried to attract into that pilot. We also had about 3,100 customers in a control group. So that process also cost quite a bit of money. We had about $4 million from Navigant, who was a consultant hired to kind of review the time of use progress and pilot results. We also had marketing costs, as I described, because we did try to get those participation targets. And then we also had meter investment. We had, at the time, not received approval for our AEGIS initiative in Colorado, and then therefore needed what we refer to as bridge meters. So kind of meters in between the current non-interval meters that were in service and what we would have with AMI. So those bridge meters were interval data recording meters, but they were non-communicating meters, kind of like what we've talked about today and in this proceeding. So, rough estimate, we spent north of $10 million on that pilot between all those components. As part of the 3-case settlement in 2016, we were also expected to make an advice letter, as they're called in Colorado, filing by December of 2019 to essentially recommend to the commission either continue the pilot specific to RETOU, continue the pilot, end the pilot, or something else. And so we proposed a modified TOU rate in that advice letter filing in December of 2019 that proposed to the commission that we go forward with making a time of use or time differentiated rate available as our default residential rate, which means it would be the standard rate, as you've heard in the context of SPS's rate structures, not an optional rate available for our residential customers. Now I'll offer for you in PSCO, the large population center served by PSCO from an electric standpoint and a gas standpoint is the Denver metro area. So there's over 1 million customers in PSCO service territory, and over 80% of those customers are located in the Denver metro area. PSCO's electric operations, residential customers represent over 40% of retail sales. In comparison, residential customers represent less than 15% of sales for SPS's system in New Mexico. So, the goals that we had and the value that we saw from a time differentiated rate in Colorado was different in Colorado. It's not to say there's not value for a time differentiated rate design in SPS's service territory, but the customer concentration is quite different here. A little info on what we learned out of that pilot was it definitely increased customers' awareness of different pricing, different periods. But we saw a lot of confusion between different prices of electricity in summer versus the rest of the year. So the pilot time of use rate was a year-round time of use rate. So we had an on-peak, shoulder, and off-peak rate for all 12 months of the year. Customers struggled to understand that power might be more expensive in the summer. And so in our modified time of use advice letter filing in December of 2019, we proposed a summer-only time of use rate to really reinforce that, again, because the residential class uses much more of the system, in Ps'S service territory, that if we had more participation in a default rate as opposed to an opt-in rate, and we really focused our efforts to encourage customer shifts in usage behavior during the summer, we might be able to maximize any value of changes in behavior to reduce system peak. So we had proposed for that to only be a summer rate. Ultimately, we settled that case, and the time of use rate that's now in effect is a year-round rate. That was a reflection of settlement positions and negotiations among the parties. But again, those goals of a default time of use rate in Colorado were really meant to maximize the system impacts of shifts in customer usage away from a peak hour. We also wanted to have a more precise pricing signal for customers. The existing rate for Colorado Electric residential customers at the time was a inclining block rate. So in other words, the more energy you use, the higher price you pay. We saw that as a stark barrier to EV adoption, which certainly had more potential in the Denver metro area than it might in some other population centers across the country. But essentially, if we were going to be charging customers more, the more they use, that could hurt or disincentivize customers from adopting EV cars or electric vehicles in our service territory. What we'd rather have customers do is charge at night or charge off peak. And so we thought a more precise pricing signal could help encourage that kind of behavior while also supporting the energy policy goals of the state. Surprisingly, for me personally, we only saw about 12% change in customers' behavior around their air conditioning and in-home, kind of temperature use. Most of the change in behavior we saw related to, at least in our pilot, related to appliance use. So I think we had some examples yesterday where customers would, maybe run their dishwasher at night after they go to bed, as opposed to filling it up and running it right after they finish dinner. So we saw that kind of behavior. But we did see some self-selection bias in the pilot as well. And actually, bill impacts for our residential pilot participants actually increased as a result of our time of use rates, again, in the pilot. Some of that was customers couldn't actually change their behavior to off-peak periods. And some of it was customers then began to use more energy usage in off-peak periods, which ultimately led to an increase in their bill. So I don't know if that information is helpful for you. That's a very broad overview of some of the key takeaways that I had from that experience. But in conclusion, it was a multi-year process. There was a lot of analysis. We made significant investments in the pilot, but really the ultimate rate design that we implemented needed to be based on some kind of assumptions, some kind of data to be able to make assumptions on how customers are going to shift their behavior or if they are going to. So in the settlement that we had in that 2019 advice letter filing, which was, I think, ultimately approved by the commission in September of 2020, we assumed about 2% of customer usage would shift from on-peak period to off-peak periods under that design. And again, that's based on kind of the usage patterns we saw shift in the pilot. Ps'S AGIS proposal was approved. The deployment plan for meters there is longer than New Mexico. It's essentially began in 2021 and will be finished by the end of 2024. So we are actually transitioning customers to time of use rates alongside that meter deployment. And what was really, really important to the parties in that time of use proceeding was making sure that customers had some data, 3, 4, 5, 6 months of interval billing data on their usage before they transitioned onto the time of use rates. So we actually move customers from the rate they're on today in Colorado to this now default time of use rate in batches or 2 times during the year, so that they are able to see that time of use usage on their bill in their My Account before they transition to the rate. And that was an attempt to help educate customers on their usage patterns and behavior before they are then subject to, those higher on-peak prices. The education component of that data sharing was very, very important to all the parties and to the commission in Colorado. But recognizing we had a 4-year deployment plan on meters, parties also didn't want to wait until 2025 to begin transitioning customers to time use rates. So that's pretty complicated from a customer rate transition perspective. Our deployment plan here in New Mexico is much shorter. New Mexico is also one of the last jurisdictions for Excel to receive advanced meters if this grid mod proposal and application is accepted in this proceeding. So some of those timeframes will be more efficient in New Mexico, shorter deployment period. A lot of the software releases and development activities that are occurring will have completed by the time we get to New Mexico deployment. So a lot of the things that we're planning to do, as we've talked about in this case, will be available upon meter exchange, as opposed to needing to have this kind of multi-year transitional approach to receipt of some of these functionalities, capabilities, and benefits.
Very well, Ms. Tremble. Any further question? You
I
were
was just
going
going
to
to offer you've had some questions about meter opt-outs, and I do have some data from PSCo on that if you're interested in it for reference. To date,
Sure.
or through early December, PSCo has deployed, I think, about 700,000 meters. We've experienced approximately 6,400 meter opt-outs. So meter opt-outs are different than time of use rate opt-outs, right? These are folks that may end up going on the rate, they just don't want a communicating meter. So that represents about 0.75% of PSCo's residential class.
And is that higher or lower than what you had projected?
We originally didn't propose an opt-out option for the meter or the rate. That was something we settled to, but I think we were expecting maybe about 1% meter opt-out, so it's a little lower than we anticipated. But again, we're only about halfway through the deployment.
Very well. Thank you
And
for
then
that.
I did listen to Mr. Rowling's testimony this morning, and I think you had a question about the percent of, I'll say, change or shift in usage or peak demand that we've assumed. So as you heard, we don't have that data, like I talked about, that we had for Colorado or Minnesota. Haven't done an expansive time of use pilot. There is studies available though, and so Mr. Rowling kind of normalized that available information to SPS's size and residential profile, which again is much smaller than some of the residential customer concentration in our other service territories. So in his attachment 4, I believe the Brattle study summarizes the energy savings and the peak demand reductions under the 3 methodologies or 3 approaches that Brattle study uses. So essentially, Mr. Rowling's cost benefit analysis concludes about a 21 megawatt peak demand reduction potential for time of use rates on SPS's system. To give you some perspective, we have about a 4,000 megawatt production peak on our system in the summer currently. So that 21 megawatts would be about a 0.5% reduction on our peak demand. So it's not zero, but that 21 megawatts in the context of a very, C&I heavy customer base and a 4,000 megawatt production peak is limited. And that's why you only see a 2% attribution of time of use benefits to Mr. Rowling's cost benefit analysis.
So the answer to my bench request is 0.5% of production peak in the summer.
Correct. Based on
Okay.
The assumptions, again, used
Right.
in that Brattle study.
Right. Okay. Thank you. Anything further, Ms. Trammell?
Oh, Your Honor. Thank you for the opportunity to share a little bit more information.
Well, thank you for coming back and providing that information. Ms. Lees? That was, yep, you're muted. There you go. Anything further on this?
I do not have any further questions for Ms. Trammell. Thank you.
Okay. I hesitate to offer this, but I would allow a brief opportunity if anyone has, these were questions or providing information for questions that I had. And would allow a brief opportunity if someone had a question. That doesn't look like anyone does.
I'm hesitant to, but that generated a couple questions for me.
I'm hesitant for you too, Mr. Getko, but if you think it's necessary, I would allow you the opportunity.
I just wanted to ask whether the 4 to 6 month period for the customers to see their interval data was chosen because it feels like that would be a good time, enough of a time period for the customers to understand their energy usage.
The parties, and this is not representing settlement discussions anyway, just general characterization of the positions. I think all parties in Colorado would have preferred more time, would have preferred at least a year. But also we're trying to optimize, this was a transition of the entire class to a default rate over the course of 4 years. So, making that process even more protracted wasn't ideal either. And so we also, as a group, all the parties in the case, understood that when customers transition to a time of use rate could be highly impactful to the customer experience as well, right? You wouldn't necessarily want to transition a customer during a summer month if they aren't well educated on the impacts of a potential time of use rate on their usage behavior. So we actually, as part of that staggered transition plan, do not transition customers onto a time of use rate during the summer months. So kind of by process of elimination, there's only particular time periods where we can, and that was the real origin of those batches. So essentially we transition customers to the time of use rates in April and October. So customers that move on to the rate in April represent customers that have received their meter from essentially October the prior year through March of that current year. So, if a customer got their meter in January, they may only have a couple of months of usage data in those time of use periods, whereas a customer that got their meter in October would have more. So we tried to stagger the batches to maximize the amount of time that customers would see interval usage data in the time of use periods before transitioning onto the rate. We didn't want anyone going onto the rate in the summer in case they're unable to change their behavior or shift their behavior. They would experience likely a high bill, and that would decrease the overall customer experience for the transition to time of use rates. So it's kind of a quiet period over the summer, then you have that next transition in October.
Thank you. And Madam Hearing Examiner, I just have the response to your bench request from yesterday, which Ms. Trammell's just been speaking about, and I could give you that right now if you'd like.
Was that the proceeding number?
That's correct.
Do you know it, Ms. Trammell?
I do. Not to get in front of Mr. Gedko, but the 2019 advice letter filing that I referred to was 19 AL 0687E.
Madam Hearing Examiner, I understood my bench request to be to the settlement agreement in 2016. So.
Okay, Mr. Gedko.
And that is a 3-part settlement. They put 3 cases together into a single settlement. And
okay.
So 16 AL-0048E, then 16 0055E and 16A-0139E. And they're grouped together on the case caption.
Very well.
And if I may, Your Honor, those proceedings, even though it was a 3-case settlement, they are actually 3 individual dockets in the Colorado filing system. The settlement agreement, any supporting testimony, decisions, subsequent filings were made in all 3 proceedings. So essentially, you could view anything you could view any of the proceedings that Mr. Gedko just gave you and find the same documents.
Very well. Thank you, Mr. Gedko. Thank you, Ms. Trammell, for coming back and providing that information and hearing. Ms. Lynch?
Yes, I have a couple of questions.
Okay.
Okay. Hello, Ms. Trammell. It's good to see you again.
Hello.
These questions follow upon the questions you just fielded from hearing examiner Hurst.
Okay.
Can you tell me whether you know if Excel takes information from its other, territories to transfer lessons learned in the various realms of, the various areas that a utility must transfer certain lessons learned to apply to other territories?
I would disagree with the characterization that we must transfer everything
No,
from each jurisdictions, but
No, I didn't.
generally, we do have electric operations in 8 states, and I have counterparts in other jurisdictions that I connect with and communicate with. Obviously, each jurisdiction, even each state within an operating company service territory is unique. So not all learnings, as you will, are applicable across all of our 8 states.
Correct, but there are times when you take lessons learned from some territories and apply them to other territories.
Sure, there are some times.
Okay. And if I heard correctly, you oversaw PSCO's implementation of default time of use rates?
I did, in the sense of the regulatory proceeding to propose that. For example, I didn't oversee, billing software changes or that type of implementation of default time of use rates.
Right, but you were there at PSCO when they implemented the default time of use rates.
Yes.
Would you agree that at PSCO there was a higher level of participation in the time of use rates when a default time of use rate was implemented?
Compared to what?
When there was no default time of use rate.
Well, I think by nature, if there's not a default time of use rate, the participation would be 0. So any participation in a default time of use rate would inherently be higher than no participation in the absence of a rate.
So would you agree that participation in the time of use rates increased in PSCO after you implemented a default time of use rate?
Yes, because it is a default rate, meaning all customers are transitioned. There's not an option to opt in.
Okay.
And that's a very important policy framework to, I think, understand. This was not an opt-in rate. And so there's an opt-out rate option. But from a customer experience standpoint and goal standpoint, that's again a very important policy consideration to take into account, whether you essentially want to move all customers to a time of use rate option or not for a jurisdiction.
Correct. Right. And you will be involved in evaluating whether default rates will work in SPS's territory, correct?
Assuming I'm still employed in that time frame and in the future? Yes, ma'am.
Okay. Let's see. So, hearing examiner Hurst, I believe that's the extent of my questions for now.
Thank you, Ms. Lynch. Just so that I understand, Ms. Trammell, does Psco still have different block electric rates for its customers?
No. So as much as the time of use rate design, right, establishing that default time use rate for our residential customers, as much effort went into that, there was a significant amount of conversation and dialogue among the parties about what we refer to the transitional rate should be. So again, the foundational criticism of our inclining block rates at the time in Psco was that it really discouraged either beneficial electrification, so electrifying, say, gas use to electric use for a residential class, or it was a barrier to EV adoption in the sense that, from a pricing perspective, customers would just pay more if they had an EV, even if they were using it at an optimal time, charging it in an optimal time on our system. So parties were very intent about wanting to eliminate the inclining block rate for SPS's what I'll call standard rate at the time. So what we actually did as a result of that 2019 filing was change our standard rate to not be that inclining block rate. Just the way the filings were in Colorado, we had what Colorado refers to as a phase 2 rate case coming up. Phase 2 is where we only do cost allocation and rate design. So they do a phase 1, which establishes the revenue requirement, and then there's an entirely different rate case for cost allocation and rate design. I think they might be the only jurisdiction in the country that does that, but that's what they do. So shortly after the modified TOU proceeding, we had that phase 2 rate case. And in that case, we eliminated the inclining block rate, standard rate, or default rate for our residential customers and converted customers to essentially a seasonally differentiated flat rate. And the reason we moved everyone to a seasonally differentiated flat rate, which is basically the standard rate that SPS has today, was to eliminate that perverse price incentive on the inclining block rate structure for increased electrical usage due to beneficial electrification or EV adoption, align the seasonality with the seasonality that would be maintained in the new default time of use rate, but also match what the opt-out rate would be. So if a customer did not want to be on the time of use rate, they would opt out to what we called Schedule RU. It was residential opt-out, but everyone called it RU, which was a seasonally differentiated flat rate as well. And we tried to minimize the noise that you would have through a customer rate transition as they moved. It's kind of complicated, as you can imagine, from a inclining summer block rate to a seasonally differentiated flat rate, potentially to time of use rate, and then if they opted out, back to a seasonally differentiated flat rate. So we're trying to make that as simple as possible and really focus on the more precise pricing signal we sought, which was that energy can be more expensive in the summer.
Yeah. Okay. And has Xhel had inclining block rates in any of its other electric affiliate jurisdictions?
I should know the answer to that question. We may have had inclining block rates in other jurisdictions in the past, but I can't answer with certainty today. Happy to take that one as a bench request if you wish.
Yeah, no, it's not that important. I just find it interesting. I'm more familiar with inclining block rates for water utilities, to encourage conservation, especially here in New Mexico, where, well, it's not that water's not important in Colorado now too, but obviously, important and So no, it was just a point of interest. So, all right, Ms.
I do-
Trammell, thank you so much. We appreciate your time, and you are excused maybe finally.
Thank you.
And Miss Hardy, anything further from SPS in this case?
No, Your Honor, nothing further from SPS. Thank you.
Thank you. Well, as our schedule indicates, the presentation for SPS is concluded. I believe the presentation of the New Mexico Attorney General has presented their witnesses, correct, Mr. Getko? And I believe that, as I referred to earlier, the next witness to be presented would be presented by intervener Walmart. So, Mr. Bartel, let me admit Mr. Teague. Okay, I see him. Hello there, Mr. Teague. If you would unmute yourself and let us see you. There you are.
Hello.
Hi. Allison, would you please swear the witness?
Mr. Teague, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Go ahead, Mr. Bartel.
Mr. Teague, would you please state your full name?
Andrew D. Teague.
And you are employed by Walmart Incorporated, is that correct?
That's correct.
What is your position there?
I am Senior Manager of Energy Services.
You have before you a copy of the direct testimony and exhibits for Andrew D. Teague that was filed in this proceedings on behalf of Walmart.
I do.
Do you need to make any corrections or changes to that testimony today?
I do not.
You adopt it as your sworn testimony in this case?
I do.
I'd move the exhibit, the admission of Walmart Exhibit 1, the direct testimony of Mr. Teague.
Mr. Teague, your answers are true and correct to the best of your knowledge.
Yes, they are.
And if you were asked the same questions today, you would answer the same way?
Yes, I would.
Any objection to what's been identified as Walmart Exhibit 1, the direct testimony of Mr. Teague? Hearing no objection, Walmart Exhibit 1 is admitted. Mr. Bartel?
I will pass the witness for cross-examination.
And Mr. Teague,
Yes.
your testimony is so clear, no one has questions. No one wants to cross-examine you today.
That's good.
How lucky are you? I just have a few questions for you, sir, with regard to your testimony.
Okay.
As I understand it, Walmart as a multi-account customer, I believe according to your testimony on page 2, at lines 10, answering the question posed at lines 8 and 9, please briefly describe Walmart's operation within the company's service territory. You indicate at line 10 that Walmart has 6 stores that take electric service in SPS's service area, correct?
That's correct.
Walmart has more than 6 stores in the whole state of New Mexico, though, doesn't it?
That is correct. As indicated in my testimony, we have 53 retail units and 1 distribution center within New Mexico.
And my understanding is that what Walmart is requesting in this case, and what they requested previously in the dismissed case, is that SPS provide the functionality that would allow you to aggregate the data from all of your stores into some kind of functionalities that you could utilize. Is that correct?
That's correct.
And my understanding from SPS's testimony is that what they're offering to do in this grid mod proposal is primarily for the residential customers using the AMI, and that what they're offering won't accomplish what you're asking them to do. Is that correct?
The data will still be there. The data will still be available, but it will be a 1 file per account, is my understanding.
Therefore, what they're not offering any type of modification or explanation that their proposed grid mod system is going to give you that functionality that you're requesting.
Correct.
Now, do you know whether or not that functionality is being offered in any of the other New Mexico jurisdictions that you currently have accounts in?
In New Mexico, no.
Is it being offered in other jurisdictions where Walmart has locations in a electric utilities operation area?
Yes.
And where would that be?
I'm getting this in multiple locations in multiple states. For Green Bun branded utilities, I'm getting that from Southern California Edison and from Pacific Gas and Electric. And I'm getting all the accounts under 1 data file, or in case of data file size, multiple data files. But the limitation there is not the number of accounts, but the size of the file.
Do you have any idea what it would, do you know whether or not it would cost SPS money to get this functionality?
I do not know.
Can you, once you get the interval data, which do you currently get interval data?
From SPS, no, I do not.
But you will get interval data if the commission approves the SPS's grid mod proposal, correct?
That is correct.
Do you know, once you have that data, whether or not you could purchase? You could contract with a third party and get that sort of aggregation of your accounts
I've
from
not,
like a third.
Mm.
Go ahead, sir.
Okay, I've not looked into that, but I believe that might be possible.
Okay. You haven't looked into it, so you don't know how much that would cost.
No, ma'am.
But it's Walmart's perspective that SPS should provide it.
That's correct.
Well, other than it having some type of cost prohibitive nature, do you have any explanation, Mr. Teague, why you think that SPS is not appearing to be responsive to Walmart's request?
I do not.
Because I mean, I asked them
Yeah.
yesterday. I thought perhaps, as the representative for the company and in your position, you might have an explanation for that.
I do not. Other utilities that use Green Bun tend to all the utilities that I've dealt with that use Green Bun functionality, or you provide data in Green Bun for data formats, provide multiple accounts per data file.
Have you sought out any of the other business entities or educational entities, commercial entities who might be similarly situated to Walmart, and tried to get a group to approach SPS
I have
to
not
say,
done
hey, look, there's 10 of us, and among us we have 36 accounts or whatever, that there might be more more leverage if you had some similarly situated companies behind you.
I have not approached other companies within SBS territory.
Okay. All right, sir. Well, those are the questions that I had for you. So, Mr. Bartel, anything further that you think we need to hear from Mr. Teague?
I have no further questions for him.
Very well. Ms. Lees?
Your Honor, just a couple follow-up. Mr. Teague, did I hear you correctly? You testified that California Sun Edison and PG&E are the utilities that provide this aggregation function that you are requesting?
Yes, I'm currently in the works with other utilities, but I'm currently only getting Green Bun connecting my data from Southern California Edison and Pacific Gas and Electric.
And does Walmart have stores in all 50 states in the United States?
We do.
Do you know approximately how many stores Walmart has nationwide?
Approximately 5,600.
And when I look at your testimony, Walmart only has 6 stores, correct, in SPS service territory in New Mexico?
That's correct.
And how many stores does it have in New Mexico?
53.
Thank you.
But just for clarification purposes, Mr. T, are you in charge of the of all the energy services for all of the Walmart stores, or a particular region?
I am not responsible for energy services in all 50 states. I have a regulatory region, and I have which contains New Mexico. I also have the entirety of the data component, but I don't provide all the energy services for all 50 states.
Okay. Thank you. Anyone have any further questions for Mr. Teague? Hearing no questions, Mr. Teague, thank you so much. You're excused, sir.
Thank
Mr.
you.
Bartel, anything further from Walmart?
No, we are concluded with our case.
Very well. Let's go on to our next witness. I believe that our next witness is Mr. Kenny. So, Ms. Lynch, is Mr. Kenny available?
Apologies, I am just trying to switch from different screens. Mr. Kenny should be available. Can you let him in?
I will let him in when I see him asking to get in. There he is. Hello there, Mr. Kenny.
Hello, can you hear me all right?
I can hear you fine. Allison, would you please swear Mr. Kenny in, please?
Mr. Kenny, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Go ahead, Ms. Lynch.
Okay, well, CCAE calls its next witness, Michael Kenny. Could you please state your full name, first and last names for the record?
Michael Kenny,
Thank you. And by whom are you employed and in what capacity do you work for them?
I work for the Southwest Energy Efficiency Project, and I'm a senior program manager there in the utility program.
Okay. Do you have in front of you CCAE Exhibit 1?
Yes,
And can you please identify what is CCAE Exhibit 1?
my direct testimony.
Was this direct testimony prepared by you and under your control?
Yes,
Is the document you recognize true and to the best of, does it represent your knowledge as true and to the best of your knowledge?
yes,
Okay. And the questions contained within would be answered the same today as they were in the direct testimony?
yes.
Okay. Do you have any changes that need to be made to the direct testimony at this time?
No,
Thank you. And with that, we pass the witness, Your Honor.
Well, let's offer it into evidence first.
Oh, thanks.
And is there any objection to the introduction of CCAE Exhibit 1, Mr. Kenny's direct testimony into the record as affirmed by him here today? Hearing no objection, CCAE Exhibit 1 is admitted. Ms. Lynch?
Thank you. With that, we pass the witness.
And Mr. Kenny? Again, your testimony is so clear, no one wants to ask you questions because they understand it, except for me, and I do have a few questions. So welcome. And my understanding from reading your testimony, you've indicated on page 3 I don't see any line numbers, but down at the bottom of the page when you're discussing the purpose of your testimony, you say that you're recommending approval, but you have some recommendations. Specifically, you think that SPS or the commission should direct SPS to modify the proposed annual report on grid modernization implementation with a few details. That's your testimony?
Yes.
And the agreements that SPS made in its rebuttal testimony, including those, have you been listening during the hearing? Did you hear, for example, that there were quite a few of the recommendations that Attorney General witness Lane made that to provide certain data? I think a lot of it as it related to green button that SPS had agreed to. Did you hear those things?
Yes.
Did that help assuage your concerns on their reporting requirements?
Certainly that those additional agreements by the company are welcomed. And I believe it was also in their rebuttal that they agreed to the additions to the annual report that we also recommended.
So that particular recommendation then, do you believe has been agreed upon by SPS?
Yes, as it pertains to the annual reports, yes.
Okay. And then your second recommendation was to hold meetings to develop new programs and rate designs that leverage the new grid components. Did SPS in its rebuttal agree to hold those meetings?
Yes.
Okay, well, you're 2 for 2 so far then, aren't you? You're doing well, Mr. Kenny. 3 recommendation was to assess conservation voltage reduction technologies. Correct? And can you just, for the record, can you just summarize what that is and what that would do?
Yeah, at a basic level, it's conservation voltage reduction technologies work to lower the voltage that is pushed through the electric system, so in the distribution system. And doing that results in fewer kilowatts needed or consumed. So most of the technologies we use in our home have a operating range of voltage that they can work with. And so the goal is to deliver power at that lower end to just save energy. And so there's technologies that you have to add to the system in order to monitor that, to make sure you know where the voltage levels are throughout your whole system and ensure that the power quality doesn't suffer at a level, is my understanding of it.
And I know that at least the benefits that are being touted of this grid mod offering in this case, SPS, it sounds like to me from the testimony, SPS is going to have a whole lot more ability to know things about its system, to fix things on its system, to do things remotely on its system. Do you know whether or not, though, they're going to be able, if the commission approves the grid modernization plan, are they going to be able to accomplish number 3 within the parameters of their offering Or are they going to have to do something different?
From my understanding, what is within this application, they would have insights to the voltage levels across their system. But in order to fully implement a CVR, the pilot or full-scale deployment might require additional technologies beyond what is included here.
Okay. Well, do you know whether or not utilizing the lower voltage could be a benefit of having a more efficient grid or a more modern grid?
Yes, it's my understanding that if, every system is different, but conservation voltage reduction results in lower costs to operate that system.
Well, I'm just wondering if, I mean, I don't know if Mr. Rowling in his benefits analysis accounted for the potential for better utilization of voltage in the grid system, or if that's even possible. I just wondered if, like I say, all of these efficiencies and abilities and capabilities that are being touted for this grid mod, if this might just be, like some serendipitous thing that happens, is they're going to be able to better or differently manage their voltage.
Yeah, and that I think speaks to my recommendation in this, which was having additional insights to the voltage levels throughout their system would enable them to assess whether it is cost effective for SPS to implement CVR.
So you just, at this point, you just want them to do a study or some type of analysis going forward, I guess, to see whether or not they could do this. Correct? And then number 4 of your recommendations, the bottom of page 3 going on to page 4, commit to a timeline for the implementation of opt-out default time of use rates. That was your 4th recommendation, correct? And they didn't agree to that.
Excuse me, I didn't hear a response.
Sir.
Sorry, correct.
Thank you.
And they didn't quite agree to that one, did they?
No.
Say again, sir.
No, they did not.
So basically, are you looking for something similar to what I just heard about from Ms. Trammell that occurred in Colorado?
I think something along those lines is what we're looking for, is a process through which a company assesses default time of use rates and ideally implements them.
Well, go ahead, sir.
Given the cost benefit analysis relying on a default time of use rate, again modified for the New Mexico territory, it seemed that to gain the full benefits of what they're proposing, the company would need to implement a default time of use rate.
Based on the testimony that I've heard with regard to the current participation rates of time of use rates in SPS's jurisdiction, there doesn't seem to be much interest, Mr. Kenny, in time of use rates. Is there?
No, with what I've heard in the testimony today, it's exceedingly small in the territory.
So if people are not, if not, I keep saying people, if ratepayers are not necessarily interested in time of use rates on a voluntary basis, how do you think it's going to go over if you don't give them a choice and you just put everybody on time of use rates?
I would think that would come down to how it is marketed and how customers are educated about the process. I think, as we just heard from the Trammell this morning, there was a robust education process as folks were rolled into the rate. And I think that, anytime you're going to change what the default, you have to match that with education.
Well, it seems like that a $10 million pilot project for double the residential participants that New Mexico potentially could have over a 10-year or more time period is a bit daunting, don't you think, Mr. Kenny?
Could you clarify?
Well, I believe what I heard about from Ms. Trammell this morning about the default TOU rates is originally there's a pilot project back in 2011. And so now you fast forward to that and they're only halfway through switching people to the default TOU rate. And it's part of this 3 case. So that's the time period of 10 years or more. It's not over. And this pilot project, and I guess cost about $10 million in Colorado. And then she said that the majority of the PSCO, 80% of the PSCO customers are in the Denver area, and that 40% of that 80% are residential. And I know that here in New Mexico, I think it's probably like 15 or 20%. So that's where I came up with half. So I'm just saying, based on the PSCO experience applied to SPS's customer base here in New Mexico, with an eye toward time and money, I am characterizing it as kind of daunting. And I was asking if you agreed with that.
I don't know if I would characterize it as daunting, but it's definitely a process that requires broad stakeholder input and something that other jurisdictions in Excel territory have now experienced and would use to streamline the process in New Mexico.
Streamline the process for what end?
Well, in the end of implementation, perhaps the cost of setting up different softwares, different back-end components that are needed to, take the interval meter data and use it for billing purposes.
Well, is your goal to you have them use less energy or save money or something else?
Within my goal is that the customers save money with a time of use rate. They may not necessarily save energy as much as they would shift it. But as we heard from Mr. Schoenheider, you can combine those rates with additional energy efficiency and load management offerings that could then further for the customer. But having that rate as a baseline from which to work is important.
Okay. I noted in your testimony, at pages 8 and 9, that you are describing the low income community and potential issues regarding internet access, and I guess I'm wondering, in your recommendation on page 9, you say, I guess to address this, the company should leverage partnerships with state and local agencies that assist low-income households. To identify the households and community that lack access. Do you have any other recommendations for how you think that this particular community could benefit from grid modernization if they don't have the internet access, and if they don't have the resources to have distributed energy or renewable energy, how they're going to be able to participate?
Well, the internet access issues would hinder, their ability to, say, have communicating devices within their house. It wouldn't necessarily prevent them from receiving the broad benefits of these upgrades, right? There's a lot of safety and reliability aspects that are included here, which any customer qualifies would benefit. So yeah, my concern there was primarily how the home area network would connect to the AMI meter in areas where homes, the ratepayers in those homes do not have reliable internet access, or potentially the means to afford some of the smart equipment.
But if a customer is going to be able to access the utility portal, and for example with a smartphone, correct?
I would assume so.
And if they had a smartphone, couldn't they also access the HON?
I'm not certain on that.
Okay. Well, as you say, some of the functionality is going to be able to be utilized. I just seem to recall some testimony in P&M's TEP case from the low income community that at least in the Albuquerque area, there was a significant number of people that had smartphones. There's a question about payment for EV charging is what I seem to recall. Okay. Very well. Mr. Kenny, that's the questions that I had about your testimony. Ms. Lynch, any redirect for your witness? Ms. Lynch? There you go.
Yeah, thank you. It's about getting this screen on the correct screen. Anyway, no, I do not have any questions for Michael at this time.
Okay, thank you. Any other questions for Mr. Kenny?
I think I just have two, Your Honor.
Ms. Lees, go ahead.
Do you recall Mr. Kenny getting questions regarding your testimony on conservation voltage reduction?
I do.
And if you go to page 11 of your testimony, and my apologies, sir, I can't direct you to a line number because there are no line numbers, but
Okay.
in answering the first question, you referred to research done by the U.S. Department of Energy. Do you know what date that study that you reference was published?
2010.
And do you know whether the technologies that study, for example, incandescent light bulbs, cathode ray tube TVs, plasma TVs, those types of technologies evaluated are still relevant today?
Broadly speaking, I believe that cathode ray TVs and probably the lighting are not as invasive in homes today, but that's really broadly speaking.
Thank you, Mr. Kenny, for your time today and for testifying. That's all I have, Madam Hearing Examiner.
Mr. Kenny, do you know whether or not there's been an updated study that's the same or similar to your footnote 17?
On the scale that one did, I'm not aware of any updates.
Okay, thank you.
Madam Hearing Examiner?
Yes, Mr. Gedko.
Yeah, if I may, there was everything just went blank there for a second. Sorry. Do you all hear me now?
I do.
Okay, sorry about that. Everything went blank for a second. I have one question, I think. There was a discussion, Mr. Kenny, about the interest in time of use rates. In your experience with time of use rates in various jurisdictions, do you find that when there's marketing of those time of use rates, that there are residential customers that do take an interest, and that more take an interest as a result of being made aware of the existence of those rates?
Generally speaking, yes, when marketing occurs, then more of the customer base is aware that they can save energy on that rate.
Okay, thank you.
All right, Ms. Lynch?
Yes, apologies. I do have one question for Mr. Kenny.
Go ahead.
Mr. Kenny, with in reference to the default time of use rates, what are some of the characteristics in SPS's territory that currently might limit participation in time of use rates?
From what I've heard in the the hearings this week, it doesn't sound like SPS markets them very heavily, that they're available on their website, but the customer would have to have the initiative to seek them out. And I think the benefit of an AMI meter is another thing that we have to consider, that having that granular data and pique interest in how you're using energy and when. So, couple the fact that it's not widely known that there's a time of use rate, perhaps, with the lack of insight to your granular data usage, I think it might hinder adoption.
And would you say that a benefit of time of use rates is to decrease peak loads?
Yes, that is one of the goals of a time of use rate.
Are peak loads increasing? Do you know?
According to companies filing, at least in the next few years, they're not expecting any new capacity needs. So it seems like their peak is at least within what their generation capabilities are. But if I recall from their energy efficiency filing, that might change outward of 2026 or so.
That's all I have, hearing examiner.
Very well. Hearing no other questions, Mr. Kenny, thank you for your time, sir. You are excused. Anything further from CCAE, Ms. Lynch?
No, Madam Hearing Examiner Hurst.
Very well. I believe now would be an appropriate time for us to take a luncheon recess. According to the witness list, we have 4 staff witnesses that are remaining. And my understanding, according to pre-hearing memos, is that only SPS has reserved time for those witnesses. So I think we should be able to accommodate all 4 of those witnesses when we come back from lunch. So I have that it's 12:15. So let's come back at 1:15 and were you going to say something, Miss Lees?
To the extent that it's, excuse me, to the extent that it's helpful, Your Honor, SPS has determined that it does not have any cross for staff's witnesses.
Okay. Sounds like it's going to be a quicker afternoon than I thought. I have questions for staff witnesses. So I suggest we take our 1-hour recess, and we'll come back and hear from staff's witnesses at 1:15. So we are recessed. Okay, we have about 2 minutes. Before
hearing
we go
examiner?
back on the record. Miss Hardy, who's still pretending to be Miss Leaves, yes.
I'm trying my best to impersonate her.
She probably would like some help with that new toddler.
Yes, I bet she would.
You probably could take care of the puppy.
I have a puppy too, so.
Well, maybe you could just share your, kind of they say with grandparents, how they get to go home. You
Yes.
could just share your puppy and then take it home, and then her son would get his birthday wish.
I think you're right. Maybe we'll work that out.
Okay. Not what you were going to talk to me about.
No, I wanted to mention that I have a correction on our costs. We do have a couple of questions for Mr. Sidler that I think would be disposed of quickly, but that's it.
Okay. I just wanted to tell people before we still have 1 minute before we go on the record. You could also, I don't know, email, chat amongst yourselves, think about whether or not you want to have offer me proposed post-hearing writing dates, whether or not that would be a proposed certification or not certification. I've had too many stipulations lately. Proposed findings, joint or separate, or briefing. People can think about that while we go through our last witnesses, and when we're finished with the witness presentation, we can talk about that. Okay, let's go back on the record. We have 1:15, which is when we're supposed to come back, and I believe, Mr. Bogatko, we are to the staff presentation in this case. And I believe you have a witness. So, Allison, if you would please swear Mr. Sidler.
Mr. Sidler, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Sidler.
Good afternoon, Ms. Hearing Examiner.
Mr. Bogatko.
Yes, Madam Hearing Examiner, may I proceed?
Please.
All right, thank you. Good afternoon, Mr. Sidler. How are you?
Good, how are you?
We have a good connection?
Same too.
Okay, I'm fine, thank you. I trust and hope, Mr. Sidler, that you have a copy of what I've provisionally marked as Staff Exhibit 1 in front of you, or readily accessible.
Yes, I do.
And I would represent to you that that's a copy of the pre-filed direct testimony you filed in this case on October 11th, 2022. Does that appear to be the same on your end?
Yes, it does.
Mr. Sidler, would you take a moment to flip through that copy to make sure that it is a complete and accurate rendition of the testimony you filed in this case on October 11th?
It is complete.
Okay. And my next question then is, it's my understanding that you do not have any typographical or non-substantive corrections to make to this testimony. Is that correct?
That's correct.
And then to be clear, here's my next question. If you were asked the questions that we see posed in your prepared direct today at this public hearing, would your answers to those questions be the same?
No, they wouldn't be.
And is that because of something that was disclosed to you in the rebuttal testimony of Mr. Nickel?
Yes, it was. Mr. Nichols responded in rebuttal to part of my testimony, and in response, I would change my testimony due to his rebuttal.
And that was in concern to the HAN that SPS has proposed, correct?
That is correct.
Okay. Other than that issue, Mr. Sidler, would your answers to the questions that we see posted in your direct testimony remain the same?
Yes, they would.
With that, Madam Hearing Examiner, number one, I would represent that Mr. Sidler will, I believe, have an opportunity to clear up this issue that's been brought forth by the rebuttal of Mr. Nickel. Other than that, though, I would move for the admission of Mr. Sidler's prepared direct testimony provisionally marked as Staff Exhibit 1 into the evidentiary record, please.
Okay. Any objection to what has been marked as Staff Exhibit 1, Mr. Sidler's pre-filed direct testimony as offered and affirmed by him here today with the characterization that some of the testimony is going to change based on some SPS rebuttal testimony. Mr. Bagacco, is there any reason why you didn't go ahead if you knew that the testimony was going to be changing, similar to what occurred with Mr. Remington's testimony, and have this marked ahead of time for our hearing?
Madam Hearing Examiner, in that it was a substantive change, and I viewed it and characterized it as, if I was to file something else, it would have been filed as SIR rebuttal with leave of the court. Failing that, and having run out of time due to some other things that came up, my option then, I felt, was to just have Mr. Sidler correct it, because it is a very simple correction in response to what Mr. Nickel brought forth in his rebuttal.
Very well. Any objection to what has previously been identified as Staff Exhibit 1? Hearing none, Staff Exhibit 1 is admitted. Mr.
Thank you for
Bagacco?
that, Madam Hearing Examiner. And I would tender Mr. Sidler for cross-examination, please.
Well, would you like to go through the correction first?
Oh, well, if that's how you'd like to do it, yes, please.
It is.
Thank you. Mr. Sidler, what is the correction that you would make to your pre-filed direct testimony in response to what was revealed in Mr. Nickel's rebuttal testimony?
Okay, basically starting on page 12, line number 16, and going through page 14, line number 3, I would delete that. And in its place, I would replace it with yes. SPS should be allowed to activate their hand system as requested.
Thank you.
And then on page 14, line 20, I would take out the word not and say SPS should be granted the request to activate the hand system requested in this case.
Thank you.
Okay, just so I'm clear, Mr. Sidler, what you would like to do in response to the question posed at line 13 and 14 on page 12, you would like to strike your answer beginning on line 16 on page 12, the entirety of page 13, and then through line 3 on page 14?
Yes, Madam Hearing Examiner, that's correct.
And then you would like to substitute under the answer portion for line 12 the word yes.
Yes, Madam Hearing Examiner, that's correct.
Okay, and then the other correction that you would like to make is on page 14 in the answer portion, answering the question posed at line 5, please summarize staff's position on these issues. At line 20, you would like to take out the word not. Is that correct?
That's correct, Madam Hearing Examiner.
Okay, and excuse me, is that the entirety of your change in your testimony, sir?
Yes, it is.
And the reason for both of those changes relates to some SPS testimony?
Yes, the rebuttal testimony of Mr. Nichols.
And why did that cause you to change your answer?
Well, I had based my original answer on a situation that happened in the Denver area over Labor Day of this year. And I incorrectly, this happened right before my testimony was due. And actually I was in the Denver area when it happened. But I looked at that as being a result of SPS controlling customers' thermostats through the hand system in their AMI meters. And Mr. Nickel pointed out that I was incorrect, that was a separate program operated by PS Colorado that for control of thermostats that people signed up for and agreed to. But it was unrelated to their hand system and their AMI meters.
Okay. Very well. Any further clarification on the testimony or qualification, Mr. Bagatko?
No, Madam Hearing Examiner, I believe that covers it.
Very well. Ms. Hardy, you indicated that you did have some questions for Mr. Sidler.
Madam Examiner, with the clarifications to his testimony that he just provided, I no longer have questions. So thank you.
You're a ping pong ball.
I know.
Okay. Well, no one else signed up. Again, Mr. Sidler, you're like the witnesses this morning. Your testimony must be very clear because they don't have questions. You have removed 3 of my questions, and so that just left me with the 4th one. Excuse me. You've indicated on your summary on page 14, that staff is in agreement that SPS's request should be approved subject to the recommendations of the other staff witnesses with the following provision, which you set forth at lines 11 through 18. Excuse me. You indicate SPS is required to pay for and perform all work that may be necessary to replace or repair existing service equipment, associated equipment at the customer locations solely to accommodate the installation of the AMI meters with the ability to recover these costs in a future rate case. SPS should not be required to pay for or replace any equipment that needs to be replaced solely for safety purposes, regardless of the installation of the AMI meters. That's your testimony, sir?
Yes, sir. Yes, ma'am.
And why did you feel it was necessary to put that in?
Well, I just wanted to make sure that SPS didn't try to charge a customer to replace a meter base to accommodate their AMI meter because it's their project, not the customer's doing. I mean, if the meter base is bad and it needs replaced, that's one thing. But I don't believe that the customer should be required to replace a meter base just to accommodate the utility.
Well, I guess my more specific question has to do with the last sentence of that recommendation, that SPS should not be required to pay for or replacing the equipment that needs to be replaced. So solely for safety purposes. So you're saying that if SPS has to do something for safety purposes, they should get their money back, right?
Well, if the meter base should need to be replaced because it's falling apart or rusting apart or there's some other problem with it, the customer owns the meter base, not the utility.
Okay.
And so, I mean, it would be, I mean, if a city inspector came and looked at their meter box and said, this is bad, this doesn't meet code, you have to replace it, the customer would have to replace that, not the utility. The utility
Okay.
would have to come and remove the meter and disconnect the power to allow the customer to fix it. But it would be the responsibility of the customer to pay to fix it if it was done just because the meter base was bad.
Okay. And is it your understanding that these meters are just going to fit right into the, what did you call it? A meter platform?
Meter base.
Meter base?
Yes, ma'am. My understanding is that these meters, they in a good situation, they should just have to pull the old meter out and stick the new meter back in.
Okay.
not
So
Any more major work is my understanding.
okay. Okay. Very well, sir. That's what I needed clarified. Mr. Bagatko?
No redirect necessary. Thank you.
Okay, last call. All right. Thank you, Mr. Sidler. Appreciate
you.
your time. You're excused, sir.
Thanks.
Mr. Bagatko?
Madam Hearing Examiner, I would call our next witness, Naomi Velasquez, please.
Oh, who did we lose? We lost Ms. Beatles. Hello there, Ms. Velasquez. Can you unmute yourself and make yourself visible? There you are. Poof.
Good afternoon.
Hello. Good afternoon. Allison, would you please swear the witness?
Ms. Velasquez, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Bagatko.
Thank you, Madam Hearing Examiner. Good afternoon, Ms. Velasquez. How are you?
And you?
I am all right. I trust and hope that you have a copy of what I've provisionally marked as Staff Exhibit 2 in front of you, which should consist of the direct testimony you filed in this case on October 11th, 2022.
I do.
Would you take a moment and flip through that, Ms. Velasquez, to make sure that it is complete and accurate rendition file testimony?
It is complete. And it
Ms.
is my testimony.
Velasquez, oh, thank you.
My apologies.
No, it's all right. You, if you were asked today at this proceeding the same questions that we see posed in your free file direct testimony. Would your answers to those questions still be the same, or would they change in any way?
They would still be the same.
And it's my understanding that you do not have any corrections to make to this pre-file testimony. Am I correct? I'm sorry, you didn't come through there. Was that a yes or a no?
Correct. That was a yes.
Thank you. Well, with that, Madam Hearing Examiner, I would move for admission into the evidentiary record, Staff Exhibit 2, which is the prepared direct testimony of Ms. Naomi Velasquez.
And I didn't catch, Ms. Velasquez, you had an exhibit to your testimony?
I did.
And you prepared that, or it was prepared under your direction and control? Gotta be audible.
Yes, it was.
Yes, thank you.
You're welcome.
Okay. Any objection to what's been identified as Staff Exhibit 2, Ms. Velasquez, direct testimony as affirmed by her here today? Hearing no objection, Staff Exhibit 2 is admitted. Mr. Bagatko.
Thank you. Thank you, Madam Hearing Examiner. I would tender Ms. Velasquez for any cross-examination or other examination from Madam Hearing Examiner.
Very well. Ms. Hardy, any questions for Ms. Velasquez?
I do not have any questions, Your Honor. Thank you.
Very well. Ms. Velasquez, again, very clear testimony. No one signed up for questions or they have abdicated their time. I do have a few for you. You have made some adjustments to what
Yes.
you believe is appropriate for the writer as offered by SPS. Is that correct?
Correct.
And we look at your testimony beginning on page 5. The question posed at lines 4 and 5, does staff have any adjustments to the cost of SPS's GMR revenue requirement as submitted in their application? And you begin your answer on line 6 through 10, and you say, yes, you removed the undepreciated legacy meter balance in current year revenue credit, and then in parenthesis, legacy meters and base rates. Is that correct?
Yes, that is correct.
And basically, you go ahead and then you say that because the legacy meters are already in base rates, there's no need to collect them in the rider, correct?
Correct.
SPS didn't agree with you, did they?
No.
That make you change your mind?
So they're currently in rates, and we had a discussion. We didn't feel there was a need for them to remove them and place them in the rider. When in the future, all of the AMI meters will be in base rates. So we didn't feel the need. We just felt it would be cleaner to remain for the legacy meters to remain in rates.
Is there, I mean,
Sorry.
is there any
My apologies.
trepidation and on staff's part about maybe not this year, but potentially in 2024 or subsequent to that, when the legacy meters are no longer in service, that there's going to be a problem with collecting them in base rates when they're not actually being utilized at that time. And it's the switch over has occurred with the AMI meters.
And that's why staff recommended that the return be credited to the legacy balance of the legacy meters, so that they would get some sort of, the customers would get some sort of credit.
But under that scenario, potentially, should SPS file another rate case, wouldn't you be collecting two different meters at the same time in base rates?
Not currently. So currently they're collecting on the legacy, well, they would be collecting on the legacy meter. And the GMR writer, which is depending on the whatever is the final order in this case, then they would start collecting on the AMI meters in the future, but there's still that transition period. But I mean, there is a possibility that during the transition period, they will be collecting on both. And that's why I mentioned earlier, we requested that they return from the legacy meters be credited onto that balance to relieve the customers of those costs and to reduce the balance of the legacy meters.
And when you reference in your testimony on page 6, you're answering the question posed at line 1, what is staff's recommendation in respect to the legacy meters? You begin your answer on line 2, and then at line 7, you say, staff recommends SPS remove the meters from rate base and request the regulatory asset in their next upcoming rate case. That's your testimony. And when you say next upcoming rate case, do you mean the one that's currently filed at the commission, or do you mean one subsequent to that?
Most likely subsequently to that, when they're completely depreciated, that's when they'll create the regulatory asset, when they pull them from rate base.
Okay, which it, when you say you pull them from rate base, are you talking about when they remove the legacy meters from rate base? Well, don't they still have, according to the testimony, like 18 or 19 years of depreciation left? So they may not necessarily be fully depreciated when they're removed from rate base, will they?
Possibility. So my apologies, but we're requesting to place them in a regulatory asset.
Right. Your testimony says, yeah, that's what I was asking about with the next upcoming rate case. Then further on page 7 of your testimony, at line 6, the question is posed, what is staff's recommendation concerning SPS's annual true-up? And you answer SPS is requesting the return on the annual true-up balance of their current weighted average cost of capital being 7.19%, correct? Yes? Okay, I'm not hearing you.
Let me see if I can get some headphones on.
Okay, when you get closer, I can hear you.
Okay.
Okay, and then the second part of that answer is staff believes that SPS should earn a return in the amount of the customer deposit rate for each true-up year, correct?
Yes.
And the customer deposit rate, do you know what it is?
I don't. It's dependent on what they collect. Is that a little better?
That is better.
Okay.
Okay, I thought the customer deposit rate was set by the commission annually.
It is, but it also depends upon, my apologies, my watch is going off. It depends upon rates. But it depends on what they collect.
Well, all we're talking about is what type of carrying charge or interest, aren't we?
Yes.
Okay. So
Sorry.
would I be correct that the customer deposit rate is lower than the weighted average cost of capital?
Yes.
And so why is it you think that that is the appropriate carrying charge or interest mechanism that should be applicable to the true up?
I'm sorry, can you repeat your question?
Sure. Why do you believe your recommendation of which rate to use is the appropriate one?
Well, it would be dependent on the PRC website. I mean, you are correct in that. And that's going to supersede what the weighted average cost of carrying is. The WAC, my apologies.
Right, but why do you think that your recommendation that the commission should take yours over theirs? What makes yours factually or legally appropriate?
Well, it's an estimate, but the true up is an estimate.
Okay, Ms. Leskis, that's the questions I had with regard to your testimony. Thank you. Mr. Bagacco, anything further?
Nothing further. Thank you, Madam Hearing Examiner.
Any questions? Seeing none. Ms. Velasquez, thank you. You're excused.
Thank you.
Mr. Bagacco.
Madam Hearing Examiner, next witness I would call to the stand is Eli LaSalle.
Hello there, Mr. LaSalle.
Hello,
How are you?
doing well today. How are you?
I'm okay. Allison, could we swear in Mr. LaSalle, please?
Mr. LaSalle, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Mr. Bagacco?
Madam Hearing Examiner, thank you. Mr. LaSalle, I sure hope you have a copy of what I provisionally marked as Staff Exhibit 3 in front of you.
Yes, I do.
And that is a copy of the direct testimony you caused to be filed in this case on October 11th, 2022, correct?
Yes.
Would you please take a moment and flip through that to make sure it is a complete and accurate copy of your testimony?
Yes, it is.
And Mr. LaSalle, it's my understanding that you do not have any corrections to make to your direct testimony. Is that true?
That's true.
Well, thank you for that. My next question then, Mr. LaSalle, is this. If you were asked today at this public hearing the same questions as we see posed in your pre-filed direct testimony, would your answers to those questions change or would they be the same?
They would be the same.
Thank you for that. And you do not have any exhibits, correct?
I do not.
Thank you for that. Well, with that, Madam Hearing Examiner, I would move for the admission of Mr. LaSalle's direct testimony into the evidentiary records, marked as Staff Exhibit 3, please.
Any objection to what's been identified as Staff Exhibit 3, Mr. LaSalle's direct testimony as affirmed by him here today? Hearing no objection, Staff Exhibit 3 is admitted. Mr. Bagacco.
Thank you, Madam Hearing Examiner. With that, I would tender Mr. LaSalle for any cross or other examination, please.
Very well, sir. Ms. Hardy, you had originally reserved some time. Any questions for Mr. LaSalle?
I do not have any questions. Thank you.
Thank you. Mr. LaSalle, your testimony also must be very clear. There are no questions from the parties. I just have a couple of questions for you. And I note on page 2 of your direct testimony, the question posed at lines 9 and 10, what's the purpose of your testimony? And you are presenting testimony with regard to, you refer to items C, D, and J, SPS's request for O&M with regard to AMI, FAN, and I guess I'll have to go ahead and say it, Flisser, through SPS's rider over the useful lives of the assets. Second has to do with the straight line 5% depreciation rate, and also SPS's proposed reporting criteria, correct?
Yes, ma'am.
And you haven't made any recommendations contra to what they have proposed, have you?
No, I have not.
I note on, sir.
Yes, when this or a similar case to this was filed previously, I had just a couple of short recommendations, but in this filing, those things which I had recommended had already been addressed in the original filing.
Were they accepted or did you change your mind?
Oh no, they were here, or at least I managed to find them. The one that specifically comes to mind was just a short recommendation last time, that once annual filings were made, that those be made available on the website to customers. And there's a kind of provision, I guess, from Excel that they will be providing updates to customers on their website. So.
Okay, very well. I note on page 5 of your testimony, you are addressing depreciation beginning at line 18. And SPS has proposed a 20-year schedule for depreciation of the assets, correct?
Yes.
And you say that there is a caveat that some utilities have been approved for a 15-year expected useful life for the AMI meters, correct?
Yes, in some jurisdictions, and I don't believe for the same exact meters that are being proposed in this case.
You mean the Itron, whatever the number is?
Yes.
Family of meters?
Yes, yeah.
Are they proposing that same depreciation life for their non-communicating opt-out meter?
That I don't know that I'm 100% sure of.
Ms. Hardy, consider that a bench request to SPS. I'd like to know the depreciation life for, is it the Amara? I think I'm pretty sure it begins with. Do you know its name, Mr. Lissow?
I believe I have it in my notes here. That's a Clara. It's ACLARA. I'm unsure of exactly how that would be pronounced, but maybe a Clara.
Okay. Thank you. Did in the 20-year depreciation is for all of the assets for the AMI, the flisser, and the fan?
With the exception of some kind of IT, yes.
And you know, I had a question about that earlier, and I asked the SPS IT witness about that. It seems like the 20-year depreciation for anything computer and software seems to be a long time to me. Does it you?
I think it depends on what specific technology you're talking about. I think if you give the example of a computer, I would say, yes, that seems like a long time frame. With respect to something like a electricity meter, I would say I don't believe so.
Even though we've had testimony that these new AMI meters are going to have like computer chips in them and communication functionalities in them. I mean, it makes it An AMI meter is quite different than a regular electric meter, isn't it?
Yes.
I mean, it's more of a computer than it is like a non-communicating piece of equipment, isn't it?
Yes.
So it's kind of like the idea with the more things that you get on a car, there's more things to break.
Yes, with any kind of introduced complexity, there are additional potential points of failure. There are also opportunities for kind of increased communication of those failures, right? In that you can improve the overall stability of the grid if you have a communicating meter that can let you know when something has gone wrong. Or even just by the lack of communication, you can know that something has gone wrong.
You rely on other regulatory decisions as support for your acceptance of the 20-year useful life for AMI meters, correct?
Yes, specifically that these are some of the largest deployments of AMI to date. And as such, some of the best and most directly relevant information that we have on the subject.
Well, you haven't cited any to me in your answer at line 16 and 17 on page 6. So could you be more specific? You say a 20-year useful life for AMI meters is supported by the decisions of numerous regulatory bodies in other jurisdictions. So who are you talking about?
I believe specifically I was referencing deployment plans. That was from a filing by Ameren, Illinois, and that they cited two separate deployment plans by Duke Energy, Southern California Edison, DTE, and PG&E. And that list is in my testimony on page 5, from lines, I think, 19 to give or take 21.
Mm-hmm. And did you do all of those came from the Ameren filing?
It compiled a number of other previous examples, sort of oh yeah.
And do you have a date on that particular filing?
I don't offhand. I would have to double check.
Did you do any independent research on your own other than from this filing?
I did do some independent research. I didn't include that in this testimony. It largely coincided with what was stated by SPS and provided by SPS in their application. To the best of my knowledge and from everything I could tell, generally 15 to 20 years has become kind of the industry standard for advanced metering infrastructure. And the 20 years of depreciation that they're proposing, to me, indicates a confidence in their chosen vendor and technology, right? To go with kind of the higher end of that scale, going with the 20 years instead of the 15 years, to me indicates that they have a confidence in their chosen technology.
Are you aware or familiar with any type of industry ranking of meter types or meter providers?
Not to my knowledge, no.
There's not like a Consumer Reports review of electric meters?
Not to my knowledge.
Have you had any familiarity with any other AMI other than the one that's proposed in this case?
I did participate in EPE's grid modernization case.
And if I recall the testimony correctly, this is the same meter?
I would have to double check if it's the exact same series or not, but at least very similar.
Seems as if I heard some testimony that the meter is in the Itron meter is the same, but the opt-out meter is different. Can you confirm or deny that?
That's my understanding. At least that the functionality of the AMI meter is the same. Whereas in this case, the opt-out meter has some capabilities to record interval data, whereas the meter that was proposed by EPE for opt-out did not.
You indicate, sir, on page 7 of your testimony in response to the question posed at lines 1 through 3, the annual report adequate to provide the necessary amount of transparency throughout the implementation of SPS's grid modernization plan. And you cite 62.813B6. And then at line 17 and 18, you say, staff believes this will provide helpful information relevant to the status of SPS's grid modernization efforts. So you believe if they provide the information in B6, that's sufficient?
Sufficient in meeting the requirements of the statute.
However, as you indicate in your testimony, there has been a commitment to provide other information on the website, as well as specific reporting requirements addressed by another staff witness, correct?
Yes.
Additionally, SPS has also agreed to provide other information based on some of the intervener claims in this case, haven't they, Mr. LaSalle?
Yes, they have.
And are you in agreement that those requirements should be included?
To the extent that SPS has agreed to provide those, and that could be helpful information to either interveners, the commission, or other interested parties, yes. As to,
go ahead,
sorry.
sir.
As to whether or not they should be requirements, to the extent that they are outside the specific requirements set by the statute, I don't know that I would say that they should be required if they are outside the specific requirements of the statute. But to the extent that SPS has agreed to provide them and they could provide helpful information, I think that could only be seen as a benefit.
Okay, and sometimes doing more than what's required by the law can be helpful to the provision of service and to the ratepayer, can it?
Yes.
Since you have indicated that you were also part of the EPE grid mod, do you know whether or not the additional reporting requirements agreed to by EPE are the same or similar to the ones that SPS has agreed to?
To my recollection, they are similar. I'm not sure whether or not they're the exact same. I would have to double check.
Did you have any specific requirements in the other grid mod case that you did not include as reporting requirements in this case?
No.
Okay. Very well. Lots of questions I had for you, sir.
Thank you.
Mr. Gatko?
Madam Hearing Examiner, just a couple questions for Mr. LaSalle, if you please.
Please, sir.
Mr. LaSalle, regarding the issue of the 20-year useful life for AMI in this case, you did indicate that that was primarily, your analysis was primarily based on the Ameren filing, correct?
Yes, sir.
Would you say that there is a dearth of information on AMI longevity at this point, or is there a lot of information out there that you could use to gauge this better?
I would say that yes, there is still kind of a lack of end of life information.
Would it be fair to say, though, as these things become implemented, that we'll develop a better database in order to evaluate useful lives for purposes of what we're doing in this case, for example?
Yes, without having had the meters in the field to the point where they have failed, it is quite difficult to establish an actual factual useful life.
So with all that said, and the information that you did have at hand, it's fair to say then that in this instance, the 20-year useful life is reasonable given those informational parameters.
I believe so, yes.
Okay, and then you also talked about earlier in your conversation with Madam Hearing Examiner, recommendations that you made last time. Just to be clear, when you say last time, you're talking about SPS's grid modernization case that was filed back in 2021 and subsequently dismissed, correct?
Yes.
And if you can recollect, was the case number for that matter 21-00148-UT?
I believe so.
Okay, I just want to make sure we have a clear record. That is all I have, Madam Hearing Examiner. Thank you.
Thank you, Mr. Gatko. So just so I understand, Mr. LaSalle, it's the specific end of life AMI information that there's not much available right now. Correct?
Yes, and specifically the way that depreciable lives are set, you evaluate not only when the majority of meters fail, or whichever technology you're talking about, but also early failures, right? Whether it's due to improper manufacturing or what have you, and also those which perform significantly longer than the majority. There are always kind of a number of in any given set that just seem to hang in there. Whether it's exceeding the expected useful life by 5 years or more than that, right? And it's that sort of end of life information that you need to generate like the actual true useful life versus the predicted useful life.
Do you recall? Because I was kind of feeling like, based on some of the testimony today, that there was a reference to, well, New Mexico is the last of the Excel affiliates to, be contemplating AMI. Do you recall the approximate number of jurisdictions that currently have AMI?
I don't recall the exact number, I'm sorry.
It seems like we heard that number. In the EPE grid mod case. Wasn't it something like over half?
That seems correct.
Does that ring a bell? Ah. According to New Mexico Attorney General Witness Crane, at the hearing transcript, page 309, in case 21-00269 UT, she provided testimony that 65% of utility customers are now served by some sort of an AMI type meter. Does that refresh your recollection there, Mr. LaSalle?
That fits with my recollection, yes.
So these aren't brand new, right? And we've heard testimony this week that this is sort of the second iteration of these meters, correct?
Yes, I'm familiar with that testimony.
Okay, but you didn't see anything, as you put it, not much end of life on those meters, so not anything with regard to, say, like years 10 through 20, to inform your 20-year depreciation decision.
Yes, if that information exists, I was unable to locate it.
Okay, very well, sir. Thank you. Mr. Bagatko?
Nothing further, thank you.
Okay. Anything from anyone else? Hearing nothing. Mr. LaSalle, thank you, sir. You're excused.
Thank you.
Mr. Bagatko?
Madam Hearing Examiner, I would call our last staff witness, Georgette Ramey, to the stand. And it looks like she's already in the waiting room.
She's already out of the waiting room.
Thank you.
Hello there, Miss Ramey. How are you? You need to unmute yourself. There you go.
Yes, I'm familiar with that testimony.
Okay. Ooh.
Miss Ramey?
Yes.
Okay, but you
Hello.
didn't see anything,
You need to turn off your
not much
YouTube.
end of life.
I know. Hold on
those
one
meters,
second. My
so
apologies.
Not anything with regard to,
That's okay. It took me a few hearings to figure out what the feedback loop issue was.
to inform.
There we go.
Your depreciation.
Almost. Nope. I still hear myself. Boo.
I do too.
Yes,
Hold
if
on.
that information
Oh.
exists, I was unable.
Okay.
Okay. YouTube off.
Okay. I think we got it.
All right.
Thank you.
Allison,
for your
would you please
assistance,
swear
Madam
in
Hearing Examiner.
Miss Ramey?
Ms. Ramey, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you. Mr. Bagatko.
Madam Hearing Examiner, thank you. Good afternoon, Ms. Ramey. How are you?
I'm okay. Thank you. How are you?
I am all right. Thank you. I hope you've got a copy of your direct testimony you filed in this case handy.
Yes.
Have the copy that I've provisionally marked as Staff Exhibit 4, I hope.
Yes.
Would you take a moment and flip through that and make sure it is a complete and accurate rendition of the testimony you filed in this case on October 11th, 2022?
Yes.
And Ms. Ramey, let me make sure here. That includes the attachments that you've included in your direct testimony, correct? It's all there.
Yes. There were quite a few.
Okay, there are. I understand you do not have any corrections to make to your pre-filed direct testimony. Am I still correct in that understanding?
Yes, that's true.
And those attachments that we see there with your direct testimony, those were prepared by you, correct?
Yes.
Now, Ms. Ramey, if you were asked today at this public hearing the same questions that we see posed in your pre-filed direct testimony, would your answers to those questions still be the same, or would they have changed for some reason?
It would still be the same.
Thank you for that. Well, with that, Madam Hearing Examiner, I would move for the admission into the evidentiary record, the direct testimony of Georgette Ramey that's been provisionally marked as Staff Exhibit 4.
Is there any objection to what's been identified as Staff Exhibit 4? Ms. Ramey's direct testimony as affirmed by her here today. Hearing no objection, Staff Exhibit 4 is admitted. Mr. Bagatko.
Thank you. Thank you, Madam Hearing Examiner. With that, I would tender Ms. Ramey for any cross-examination or other examination, please.
Very well. Ms. Hardy, any questions for Ms. Ramey?
I do not have any questions. Thank you.
I know, Ms. Ramey, in one of the last couple of cases, I heard, I suggested that we change the order of presentation with regard to staff and intervener testimony, because I really feel like that staff is being shortchanged. Do you recall that?
Yes, ma'am, I do.
And I didn't do it this time, did I? No, staff is going last and everyone is exhausted, I guess. And or staff's testimony is just, staff and interveners is so clear, no one has questions but me. So
Well, I think we
anyway,
saved the best for last.
yeah. Okay, there you go, Miss Ramey. Saving
That's
the
my
best for
attitude.
last. Yeah, absolutely. Well, you know me, I always have a few questions.
We want to be thorough.
Absolutely, we want to be thorough. Help me with that customer deposit rate. That's set by the commission, correct?
Yes, it is.
On an annual basis, and it's located on the web. Do you know what it is right now?
I'm sorry, I haven't checked it recently. To be honest with you, no.
Do you recall we utilized that in the other grid mod case?
I was not a party to that, or I didn't participate in that case, so I'm not familiar with it specifically.
And I don't remember that point. Okay, so I will look up on the commission website and. Well, actually, I won't. Mr. Brigatko.
Madam Hearing Examiner.
Since it's staff's recommendation to use the customer deposit rate, consider it a bench request that I be given that information.
Yes, ma'am, I will do that. Thank you.
Okay. Ms. Ramey? For a number of years, you indicate on page 4 of your testimony that you began your employment with the commission in June of 2006, correct?
Yes, ma'am.
But for a number of years, you only did telecommunications cases. Isn't that correct?
Yes, I started in the telecom bureau at the commission.
And how long have you been doing utility cases?
I've been at the commission for 16 years now.
And how long have you been doing non-telecom cases?
Since 2018.
Are you having more fun?
Oh, I'm sorry. I moved from the telecom bureau to accounting.
And are you having more fun?
I'm having a lot more rate cases than in telecom, that's for sure. It's definitely a different animal.
Do we even have rate cases in telecom anymore?
No, and that was part of the reason for my move back in 2018 to use my accounting and finance background to work on other utility cases.
Well, in working on utility cases, and providing testimony in this case, you're describing, beginning on page 11 of your testimony, the question posed at lines 4 and 5, how does SPS propose to mitigate the number of customers who opt out? And you're answering that beginning on line 6, continuing on to page 12. Line 6 and 7, you say the company expects approximately 0.5% of customers to opt out. That's your testimony?
Yes.
Does staff have any question with regard to that particular proposal by SPS?
In terms of their approximation, you know, okay. No, we didn't really have a question or a reason to question that estimate, you know, because that is based on their experience in other jurisdictions where they have implemented the programs.
Okay. Then you go on further on page 12, and you're talking about the charges. Now you've got some issues with what their opt-out proposed charges, don't you?
Yes, ma'am, we do.
But you did not propose a specific different number, did you?
No.
Why not?
Well, the plan that they presented and the cost were supported by the data. So it seemed reasonable, but our concern was that it could be prohibitive for some customers in their territory to opt out because of the cost that they're requesting. So, staff felt that, there may be some people out there that would not want to have the AMI meter installed at their residence, but due to the cost, they would wind up having to have to participate in the change anyway, because they wouldn't be able to afford, especially the monthly fees of over $20 a month. And it does seem to be the trend based on my testimony that that's the norm for this implementation of the AMI meters, is that the customers that do not want to have them pay for alternate meters and for the additional charges related to them.
Well, I know you said that you were not part of the proceeding, but are you aware that the settlement amounts in El Paso Electric's grid mod were less?
Yes, I am aware of that.
Than the proposed opt-out charges being proposed by SPS.
Yes, and staff would definitely prefer to see lower rates for the opt-out in this case, especially as compared to what was stipulated to in Xcel Energy's case in Colorado, and then the EPE case here. It's more in line around $16 for a monthly opt-out fee versus $21, which is what the company proposed here.
Well, I know on page 14, you're answering the question at line 14 and 15, are SPS's proposed opt-out fees reasonable in comparison to opt-out fees imposed in other states? Line 16, you say SPS's proposed opt-out fees are consistent with the types of fees charged by the utilities in other states. SPS at line 18, proposed opt-out fee appears to be reasonable in comparison. That's your testimony?
Yes, ma'am, it is. It is reasonable because it falls within the range that that seems to be prevalent. But what you're asking is, if we could get it $5 less, then we would prefer that.
Well, I'm not suggesting that that there's any particular thing. I'm just trying to put things in context and understand your testimony, Ms. Ramey. No, okay. I'm not saying it's like at the flea market where you're trying to get somebody down on their price. I just wanted to point out. Did you read Ms. Crane's testimony?
Yes.
Attorney General Witness Crane.
Yes.
Were you familiar that I believe that her testimony said that the fees, that opt-out fees that SPS was proposing in this case were higher than those in other states? Do you recall that?
Yes, she did make that argument that they were on the higher side.
Well, do you disagree with her?
Well, there's a good range of prices for the monthly opt-out fees. And especially for New Mexico, which is a fairly poor state, as I said, if it could be lower in the 16 or upper teen range versus in the $20 range, it would definitely be preferable for ratepayers here. But it has been consistent with what they have proposed in their other jurisdictions. So that is what I'm looking at, the filings that they've made in Colorado and Texas, as well as here, were in the $20 ranges. And then, but in the end, due to settlements, say in Colorado and in the Texas, the monthly opt-out rate, as well as the initial opt-out cost, did wind up being lower. And that is definitely preferable for us here in New Mexico from staff's point of view.
Well, and and I saw your testimony further on page 16 and 17, where you do note the settlement opt-out fees. For example, in Texas, it's going to be $16 per month, correct?
Yes.
As opposed to 20.
They had proposed $25 there.
But 2114, I guess, is what they're proposing here. So yeah, so $5 higher here than in Texas, right?
In the final settlement, yes, but their initial proposal was $25.59 per month, which is higher than what they proposed here.
So you give your overall view which is basically that you're not opposed to the opt-out proposal, correct?
No, we're not. But I would also note with our concerns, and that was one of my attachments, due to the initial cost for opting out of the meters, staff did inquire whether they had a payment plan available to ease the financial burden on some of the customers here in New Mexico, and they did respond that that option was available. Say if the $200 initial opt-out fee could be spread out over a 12-month period, and so the customer may find that a little more amenable and affordable to do than a one-time lump sum payment. So they did, SPS did state that that option was available for customers that may want to opt out but can't afford to make that one-time payment. So we were, I guess, pleased to see that that option was available.
Well, let me ask you this. When staff was analyzing what costs were going into the opt-out charges. And you're describing the process as beginning on page 9 of your testimony. It was in reading your testimony that it became crystal clear to me that in addition for the cost of the meter, that the opt-out meter charge included a future truck charge for installation of the AMI meter when the customer who had requested opting out was no longer at the premises. Did you understand that?
I think I got a better understanding of it during the hearing, to admit. Yes, I remember seeing that in the plan, but I would say that based on the testimony that I've heard here during the hearing, it did seem like a bit of a stretch, especially I think when one of the witnesses, brought up the fact, well, what if the customer that opts out stays in their house for the next, or stays at their premise for the next, 40 years? Then, that seems to staff that, SPS is trying to collect a fee that for an activity that may never occur. So I would, kind of question that methodology that's been proposed for the opt-out fee, because it does seem to make an assumption that may not occur. And a lot of people do stay in their residences for a long time, and they may not ever want to have a AMI meter. So I'm not sure what the best approach to that is in terms of modifying the opt-out fee, to not include some future event that may not occur.
But that wasn't something that you thought about when you were analyzing the opt-out fee.
Not really, no.
Why not?
Like I said, I read it, and it's like, oh, it made sense, but I didn't look at, some of the other possible scenarios. And when they came up during the discussion here, it was like, oh, yeah, that's something to think about.
Okay. And so let's talk about your testimony on the rider.
Okay.
And staff has proposed some changes about what can be recovered, specifically as it relates to legacy meters, correct?
Yes.
And basically, my understanding is that staff wants to remove the legacy meters recovery that's being requested in the rider and leave it in base rates.
Yes.
Until such time as AMI is included in base rates? It was
Yes.
unclear to me when, if, based upon the testimony I've heard, I believe the current legacy meters are still have like almost 29 years of depreciation left. Does that seem right to you?
I do recall hearing that during the hearing this week, that there was, but I think that's like a composite depreciation rate. But they're proposing to recover the legacy meter cost over 10 years.
10 years.
Now, and so that would remain in base rates. There would be no credit in the GMR related to the legacy meters.
So you want to maintain the status, you being staff, wants to maintain the status quo with regard to the collection of legacy meters and just treat the writer with regard to the O&M for the grid mod project and any depreciation and ADIT and whatever else is associated with that?
Yes, it would only collect for the new meters being placed in service.
SPS didn't agree with that, did it?
No, they didn't, but that's not surprising.
Well, do you see any disadvantage for treating it this way as opposed to, I mean, I know we hear in every case about regulatory lag, but considering the frequency that SPS files rate cases, I mean, do you see that as an issue for wanting to treat the legacy meters differently, or?
Well, of course, treating the legacy meters differently would be a financial benefit for SPS. And that's why they're proposing it. I do believe that SPS does file regular rate cases. You know, they're coming in like every 2 to 3 years. So, you know, as suggested, say by Witness Crane on behalf of the AG, you know, where it's like, no, they're not going to miss out on, you know, collecting the depreciation on the legacy meters. You know, we could reset the GMR to 0, you know, as an option. But, you know, we want to make sure from staff's viewpoint that they are allowed to collect the funds that they'll be using to implement the AMI. So staff wants to support the efforts because, you know, we are required by statute to make this transition of the grid, and there are costs associated with it. And so, you know, it's only fair for them to be able to collect those funds in a timely manner. So we think, you know, that they can just remain in the base rates. And once SPS comes back for their next rate case, the AMI meters will be placed into rate base, and the legacy meters can be, continue to collect the depreciation that's been agreed to for, 10 years. Because they will be removed from the rate base, but they still should collect what they've expensed on that, but in a limited way, because the legacy meters will no longer be in service. And so we think that's very important. The customers don't have to pay for 2 meters at one time, when they're only using, say, an AMI meter, a legacy meter, or the opt-out meter.
Well, that's a very nice segue into my question I was thinking about, whether or not staff had an opinion on New Mexico Attorney General Witness Crane talking about return on and return of, and the element of risk, and basically that there's really not a guarantee, but it would appear that whether with the way that SPS has proposed this, is there appears to be very little risk on the part of the company about getting any or losing out on either what they paid or what they are authorized to potentially get, is there?
I guess I'll answer. It is known, I guess in utility regulation, that companies are not guaranteed a return. They may achieve it or they may not achieve it. And so with the transition that we're facing or undergoing right now in the industry, I think the company trying to ensure this return on investments that are no longer in use is unfair to ratepayers, and that the risk really should be absorbed by the company.
Ms. Raby, I'm sorry, have you finished?
Well, I really didn't, I guess, put that in my testimony, but that is the state or the status of, how utility regulation works. Sometimes they will earn the expected return and sometimes they won't. And I think under these circumstances, to force ratepayers to try and pay a return on something that's not being used in providing service shouldn't be borne by ratepayers.
Did you or any of the other staff witnesses address the commission's additional information requests that were in the final order that dismissed the prior case?
I'm sorry, what are you asking about the dismissal of the rate case?
Yeah, the dismissal of their prior grid mod case. That order dismissing that case, the commission dismissed it, but they said, oh, and by the way, we want you to address this and this and this.
Yes, I did. I have some information about that on at the end of my testimony. I believe page 27 is what I have. Commission concerns related to that case that was dismissed.
And did you look at the rates?
I'm sorry, did I look at what?
Did you look at the question about how much of an increase have you gotten in the past 5 years?
I know that that was addressed by some of the witnesses in their, what did they call it? Supplemental?
Yes.
Testimonies, yes.
Okay, so you looked at that?
Yes.
And did that have any impact on your analysis in this case?
I'm not sure what you're asking. I'm sorry.
Well, I just wondered if, and I'm looking for it, but I don't recall the exact amount. I think it was over 15%. And I just wondered, if you had any concerns when you were evaluating this particular offering by SPS, which, if I recall correctly, is, over $3 million higher than the last one that they offered. The one that got dismissed, that they asked that it be dismissed. And so I just wondered, you read those things and whether or not that has any impact on how you do your analysis in this case, or no?
I guess somewhat, but not in a material way.
Okay.
Because of the fact that the company is required to make this filing, and the commission is required to review the plans and support the implementation of grid modernization, as our, leaders have, memorialized in statute. So, we're just doing our jobs to support the initiatives that we are required to carry out.
But you understand why that the commission might be concerned with serial increases that in their mind have started to affect ratepayers, potentially, especially residential ratepayers, don't you?
Yes, absolutely. I know there was quite a bit of concern, for I guess what is known as pancaking of rates, and that, like you said, there was probably, I don't recall right off, but probably a good 15+% increases that the residential customers have seen due to the number of rate cases that have been before the commission by SPS over the last several years. It is unfortunate that that is happening, but there are reasons, for that. One of them, of which is related to the grid modernization statute that, you know, the companies are expected to come in and make these improvements and expect to be able to recoup the investments that they are making.
Ms. Raby, does the utility division still have the structure in case assignment where different knowledge and job types are assigned to a case and one particular individual is the coordinator for the case?
Well, we've had quite a few changes in the utility division. I believe that's what you had asked. I didn't hear the first word, but that's the division I'm in. So it used to be that way. I think we are making some transitions due to, we have a new director. They came in August, and then we've had quite a few new staff members that have come and gone. So I would say the utility division is in the last, especially year or so, undergoing a change. And so that may not necessarily be the case now. I think it is somewhat, but I'm not sure going forward if it will be that way, where you do have, you know, well, all these people always work on SPS cases and all these people always work on P&M cases. I'm sure that's the goal, to maintain, you know, the expertise from one case to the next, but it may not always be possible too, based on, you know, when the filings come in and the availability of staff. So the division may want to have it that way, but they may not always be able to, based on what else is going on.
Okay, and I was being more granular than that, as far as it used to be that they would assign, for example, an engineer, somebody from accounting, somebody from economics, and an attorney to a case, and one of the three disciplines would be considered the case coordinator to coordinate the activity and keep things together or whatever. And it never could be the attorney. It had to be, you know, one of the utility division people. Is that still the case or no?
Yes, we do still have case coordinators for
Who's the
each
case coordinator on this case?
On this case?
Is it you?
No, it's not me. It's Jack Sidler was the case coordinator for this case.
Okay, well, thank you for, you know, just enlightening us on on the status of that. I just have one more question for you, and I don't recall seeing it in anybody's testimony. So I'm going to ask you.
Okay, lucky me.
and that just has to do with you heard Ms. Trammell come back. SPS was nice enough to provide her to address my questions with regard to exactly what kind of process would be utilized, and that SPS thought was appropriate for both the true up annual report August 1st filing and the October 1st revenue, I think she referred to it as the advice notice filing, or on the revenue requirement, and I'm assuming potential change in the writer collection rate. You heard that testimony?
Yes, I did.
And did you or anyone on staff review what kind of process that you thought should occur for these two types of filings?
Well, listening to the hearing this week, and based on what Ms. Trammell said this morning, it did make sense. I don't think, staff thought about it in that perspective, because I think it was more of it's because it was brought up by you, Madam Hearing Examiner, about the second report actually being more of an advice notice, which is actually what it would be. And that's what Ms. Trammell discussed this morning. So the way she described it does make sense to staff from a procedural standpoint. At least that was my impression of the testimony that she gave this morning, where the report to be filed on August 1st would be more of a compliance and informational filing, which will contain a good bit of detail to address, specific issues that have been filed in the various testimonies, that especially with SPS agreeing to quite a few of the additional criteria that was proposed. And that, that would represent and provide the true up details, and that when the advice notice, which is what it would be, because it would be a change in the rate, and that it should be properly noticed, especially to customers that will be impacted by the change, to have time to review it, and that it could result in another rate case if protested enough or whatever within the time frame, or if staff found that there was some unexpected change, then that could make things a lot more complicated going forward. But that does seem to be the proper process that it should go through.
But am I correct that staff didn't address this in their testimonies that you're aware of?
No, I don't think we did, because when I look at—
Why not?
No, and not to that, definitely not to that level of specific, being specific to that level of proper process. No, we didn't, but we would.
Staff needs to.
Yes.
I mean, if there's going to be proposed filings, the commission needs to hear from staff about what staff thinks is not only appropriate, but what comports with with staff's procedural rules, what this not only the statute, but also, like you say, the procedural rules, because staff actually is in the best position to know what comes in from all the utilities on a particular issue. So I encourage staff on these procedural process questions to get involved, because the commission needs to hear from you. The other parties need to hear from you. I mean,
staff will definitely do better moving forward in that regard, Madam Hearing Examiner.
Because obviously you can tell from the questions that I had an issue in the, if you saw in the prior grid mod case, I had an issue with the procedure, and I made my recommendations, and the commission adopted them. Now, whether or not they actually have been addressed as I recommended in the rulemaking, I don't know. But obviously, and people want to read it or not. It's in the certification and stipulation in 2100-269, and and it begins on page 77, and it's entitled The Annual Rider Review and Reconciliation Process. And obviously, I'm real concerned about notice. And part of my big concern is that I don't believe that noticing something like called a rider one time, and if that rider is going to be in effect for 10 or 20 years, and how much the customer is going to be charged is going to change every year. I don't think one notice is good for 20 years. One size does not fit all in my thought, and that's kind of what I said in that in that section. So but so I got to say, I was a little disappointed that that people aren't opining on that. I mean, I didn't have SPS say, "Oh yeah, we saw what you did in this case. We disagree with you." So I mean, they're going to say what they say in this case. So far, from an evidentiary perspective, what they're saying is, here's what we're doing, and the basis we're doing this is because the commission approved this process in the transportation electrification program, that in that order, which of course I'm going to look at. But anyway, yeah, notice and having the ratepayers informed, again, especially in the variability of some of these rates. For example, I know, just, again, referring back to that EPE case, it might just be a few cents a month now, but potentially at the highest, it could be $4 or $5 a month. So yeah, your customer may not care if they look at the rider and it's 2 or 3 cents a month, but chances are, if it's going to be $4 or $5 a month, then the customer's going to go, well, what the heck is this? And no one ever told me about this. It's like, oh yeah, we told you 10 years ago when we first authorized this. Might not have even been a customer 10 years ago or 5 years ago or whatever. So again, just looking at the processes. Also, I'm not always real convinced, quite frankly, when the argument is made, oh, well, we do these energy efficiency and we do these renewable riders. And it's like, yeah, and you have a whole different rule and statutory requirement for the filing of that. And you have to have this, and this, and you have to have a certain kind of notice every time, even if you're not offering a new program. And so anyway, I'll stop at that point and just say, for all the parties, notice is important.
Understood,
leave it at
Madam
that.
Hearing Examiner.
Ms. Ramey, that's all the questions I had for you. Mr. Bagatko, anything further from your witness?
Nothing further. Thank you, Madam Hearing Examiner.
Thank you, Mr. Bagatko. Anything further from SPS or anybody else? Doesn't look like it, Ms. Ramey. I appreciate your time and you are excused.
Thank you, Madam Hearing Examiner. Have a good afternoon.
Same to you.
Thank
Mr.
you.
Begacco, anything further from staff?
Nothing further from staff. We rest. Thank you, Madam Hearing Examiner.
Very well. I believe that we are at the end of our evidentiary portion of our hearing. And there it is. I had 3 notes. Note number 1. I have received the corrected SPS Exhibit 8. It's in, I believe I've moved it on over to the Dropbox. So if you all would like to, I think it's available for you to view. Number 2. I would like, if possible, any of the bench requests to be complete by the end of this week and filed in the record. Does anybody think that's not possible, Ms. Lees?
Madam Examiner, would it be possible?
I'm sorry, Ms. Hardy.
Ms. Hardy, yes, thank you. Would it be possible for us to have 1 week from today?
Sure.
Okay, thank you. That would be very helpful.
So, that's next year, 21st?
Yes. Yes, thank you.
Okay. Mr. Getko, were you going to say something about that?
Just, if we provided a response orally, is that considered complete, or do you need a written follow-up as well?
No. If you provided your response on the record, no.
No written follow-up needed. Thank you.
Not necessary.
All right, thank you.
No, I was going to say no need to kill trees, but we don't even do that anymore. So save bandwidth, I guess.
Save, yeah, save lithium.
Yeah, exactly. Was that your only question, Ms. Hardy?
I would like to review the list to make sure we have addressed all of the bench requests, or that I have them reflected accurately. If that's
okay, go ahead.
Okay. The first one was for Piesco's WAC. We provided that orally in testimony. The second one was updated status of our TOU experimental rate. Mr. Luth provided that.
Yes.
Okay, and then the third one we have as being the cost of the proposed AMI proposal in this proceeding. Do I have that correct?
Yes.
Okay. The third one is on the customer notice.
That was 3, wasn't it? Wasn't that 3?
Yes, that was 3. Yes, thank you.
Okay.
Number 4 related to the notice to typical customers and 900.
The bill impacts.
Yeah, the bill impacts. We'll provide that.
Yeah, from what we put in our notice versus what the testimony was.
Right, the bill impacts, right?
Yep.
Okay. And then the next one was
5.
under SPS's proposed amortization period for the legacy meters. How much would the carrying cost be?
Yes.
Okay. The next one we have as being the legacy meter cost recovery treatment in Excel's other jurisdictions.
Okay.
And then the last one that we have is the depreciable life of the opt-out meters.
Yes.
Okay. And that was all of the request we had noted.
And I believe Mr. Getko answered the Attorney General's. And so that left me with staff and the customer deposit. Was there one more from staff, Mr. Pagatko, or just that one?
I believe that's the only one regarding the customer deposit rate. Thank you.
Okay.
Thank you.
And I don't think I had any for anybody else. I'll try to be more fair next time and make sure everybody gets some. I don't want you to feel left out. Okay. All right, so we want a week. So the 21st, those are due. And then also I'd like to know whether or not pursuant to commission rule 1.2.2.35. Okay. Additional evidence. At any stage of the proceeding, the commission or presiding officer may require the production of further evidence upon any issue. Such evidence may, at the discretion of the commission or presiding officer, be in writing or presented orally. Some of these were presented orally, some will be presented in writing. All parties and staff shall be given an opportunity to reply to such evidence submitted and cross-examine the witness under oath. Are the parties in the case willing to waive their opportunity to reply to the evidence and allow me to admit the additional evidence submitted in the bench request, which will be verified by the party who submits them? So we will have an under oath attribution to the information. Are the parties willing to waive any objection to admitting those bench requests? Tell me if you are going to object. Okay. Not hearing that anybody's going to object, then I will include the responses to the bench request filed on or before December 21st into the record. Okay. Item 3.
Hearing examiner.
Mr. Gatka.
Sometimes I take advantage of these opportunities to learn. I heard in there that it also presents the opportunity, not that I'm looking to do it, for cross-examination based on those bench requests. Does that get handled through a request to the hearing examiner and all parties, or how does that work?
Well, you'd have to file something. I've never seen it done, but that's why I'm asking you. Normally, by the time I've issued the decision, any objection period has, any relevant objection period has probably already occurred, and any request to the hearing examiner to open the hearing back up and cross-examine that witness. Your time would have already lapsed on that, but no, I haven't had it happen before. But as you can tell by the rule, that's why I'm asking you now if you're going to object. And no one's going to object, so I can generally I include. Let's see if I did in this case, Mr. Getko. Okay, so normally what I include, so for example, in the certification of stipulation that I issued, normally issue, and specifically issued in 21-00269, at item 17 of the findings and conclusions, El Paso Electric and the New Mexico Attorney General's post-hearing responses to the hearing examiner's bench request made during the hearing shall be considered evidence of record pursuant to, and then I cite the rule.
I'll go back and read it. I was interpreting an objection to it to be different than cross-examination of the witness. So
I think that if you don't want it, and that's why I'm asking you now, that if nobody wants an opportunity to reply and cross-examine on that particular issue, parties are willing to waive it, then I'm going to go ahead and admit it.
I'm with you. Thank you for that.
Okay. Yeah. Again, just trying to cover all our bases so we don't have anything come up. Don't know that it would. That's the rule. Okay. No objection to that. So that will be admitted pursuant to that rule. And the last item I had was a time frame for any post-hearing writings. Does anybody have anything to propose? Any date?
Madam Examiner,
Ms. Hardy.
Thank you. I would propose that the parties submit their initial briefs on January 13th with response briefs due on January 27th.
Any objection to that time frame? Mr. Gadko?
I have both a hearing that week, a possible appearance for an oral argument at the Supreme Court, as well as a stipulation deadline. Those are all in that week?
Which is that week? The 13th?
The week of the 9th to the 13th. And I don't know if there would be too much pushback against perhaps moving that deadline into the following week. That's my at first blush checking that.
That's fine.
Any objection to saying the 20th and the 31st?
That's fine with SPS, Madam Examiner.
How's that, Mr. Getko?
The 20th for initial and the 31st for response.
Uh-huh.
Could we go to the 3rd? I also have a hearing on the 30th and the 31st. And
okay,
that would be 2 weeks. So
okay. All right, so January 20th for any initial writings. February 3rd for any responses if absolutely necessary. Obviously the or not. The one issue I would like to see parties respond to is in fact the issue that I brought up with regarding the appropriate notice and commentary on on what should be included in primarily the rider filing. I think it's important. These are new, and I think we ought to try to make them as consistent as possible. To the extent it's appropriate among the differing utilities. And if it doesn't need to be that complex, then tell me. But I would like, to the extent the parties think that they have something meaningful to offer, I would like the parties to brief that particular issue. Okay, that's pretty much my end of hearing requests. Do we have anything from anybody else that we need to discuss? No. Okay, very well. Let me thank you all for your participation in our hearings this week. And I will wish you a restful and happy holiday time frame. Or if you're working, I hope that you're you know, that you get what you need to get done and get some rest. And otherwise, thank you. We are adjourned. You may leave. Allison, would you please stay?
Thank you.
Okay. Thank you.
Thank
Bye,
you.
everyone.
Thank you.
Happy holidays.
Thank you, Allison.
Certainly.